Magandang hapon at umaga sa inyong lahat. Welcome to the HR Cafe, your weekly learning habit. Today, we are very excited to have Attorney Alvin Alburo as our guest speaker today to talk about a very important topic, which is how to terminate employment without getting trouble in the law. Kasi napakaraming tao po ang mahilig pong mag-terminate pero nagugulat na lang po sila pag nagkakaroon sila ng problema sa dole. Here is how to prevent it. But before that, we would like to greet everyone good day. And for those who are watching, almost 100 people po ang nanonood live and probably more kasi napaka-hot talaga yung topic na to. Please leave your name, where you are in the Philippines or anywhere around in the world so that we can actually give you a shout out at the show. So,
Mm,
right up, the HR Cafe program provides timely news and updates, impart knowledge and experience that are value adding and beneficial. We discuss problems, issues, and challenges and provide answers and resolutions through our guest resource. We discuss new technology, tools, and processes as well as industry best practices. We do serve as a virtual job board and job related announcement. We bridge understanding between employers and employees and provides inspiration and motivation for everyone to start off their week right. Welcome to the HR Cafe. We have a few parts. First is the Wow Quote of the Week, important HR news and updates, HR question and HR learning of the week, and the free training program with our guest speaker, Attorney Alvin Alburo, later on. So, just to start, we would like to introduce our HR Cafe servers. Of course, wala po tayong HR Cafe host kung wala po si Coach Darwin Rivers, the founder and CEO of the Philippine HR Group, the largest online community for HR practitioners in the Philippines. We also have Mentor Rona Florentino, the CEO of Uprush Social Geekers. There's me, Mentor Tina Koang. I am an operations and HR leader and a well-known content creator of tinainmanila.com. We have Mentor Neil Lomakad, VP Externals of the Philippine HR Group and a learning and engagement leader. And of course, Mentor Alan Cañete, a learning and OD consultant and a leader, an HR leader of his own field. Alan Cañete, please, Mentor Alan, please introduce yourself to our
Good
audience.
afternoon, good evening, and good morning to all of you, wherever you are in this beautiful planet. I would like to welcome you to our HR Cafe episode for today. And I am Alan Cañete. I'm one of the board members of Philippines HR Group. And this wonderful podcast, or shall we say, online talk show, has been around since ano no pandemic pa, and
Mm,
until now we're doing the service to all of you. We're building a collaborative space for HR professionals like you. Kasama na po yung mga curious members and employers who are also our members here. So, together, let's share insights, discuss challenges, and foster a community of support. So, let the show begin. All right.
all right. And with that, we would like to first talk about the HR. We also have Mentor Oliver Requelman, adjunct professor and in Far Eastern University. We have Mentor Ray Fremista, Senior Director of Process Engineering. Mentor Bonnie Factor, founder and CEO of Leading with Success Inc. Later on, we will have Mentor Jamie Iris, MD of Empower to Excel Training Consultancy Services, and Mentor Jackson Ketson, Senior HR and Stakeholder and Engagement Director. And with that, let us all start with the wow quote of the week. A genuine leader is not a searcher for consensus, but a molder of consensus by Martin Luther King Jr. Sa mga nanonood dyan, na mga nagigreet, if you do have insights for the wow quote of the week, this is your chance na magpasikat and to input your comments po
All
on the
right.
chat box below. Sir Alan, what is your thoughts sa wow quote?
Let me read again. Ang ganda ng pagkasabi ni Martin Luther King, no? A genuine leader is not a searcher for consensus, but a molder of consensus. There are three ideas here. The first idea is genuine leadership. So for me, this refers to authentic leadership that is based on sincerity, integrity, and a true commitment to organizational values and goals, di ba? So genuine leaders are those who lead with purpose and conviction. Now, hindi natin naiwasan bilang mga leaders. Sometimes our members run into conflict, yung bang mga magandang ideas nila nagbabanggaan. Our role as genuine leader is to make sure that there will be agreement in the end. But ang sabi ni Martin Luther King, you should not be a mere searcher for consensus, rather a molder. Anong kaibahan? Instead of merely trying to find a common ground or agreement among team members, a genuine leader does not prioritize consensus as the ultimate goal. Ito yun, no? They don't just follow the crowd or seek approval from others. Anong gagawin niya? He should become the molder of consensus in that the genuine leader takes an active role in shaping consensus. Active role. Ibig sabihin, you become the facilitator of the meeting or the event where a lot of brains are trying to come up with a good solution. Kaya lang nagtatag-o-war yan eh. Rather than waiting for the agreement to naturally emerge, a genuine leader actively influence and guide the process of consensus building. How? This involves, unang-una, you articulate a clear objective or vision for the meeting para hindi makalimutan. Baka maya, naghihilahan sila because they have their respective vested interests. So, when you remind them of the clear vision or the goal of the meeting, people will become again reminded that oh nga pala it's supposed to be the ultimate objective, and we should be guided by the objective, the goal, or the vision, no, of that meeting. So the leader here should foster open communication, inspire others to align their perspectives and goals. Sabi nga, kung may mga vested interest yung iba, they will have to sacrifice or compromise or look for the other side of the coin, no? Look at the other side of the coin and with the overall objective of the organization. Nang sa gayon, that meeting will become productive. So the leader here, the genuine leader, is not just um, in that meeting passively waiting for the consensus to happen. Kailangan active role ka. Ikaw na mag-facilitate, ikaw na gumawa na siguro ng criteria, what should be the criteria for a better solution that everybody will agree on. Rather than consensus seeking kasi, kumbaga half-half yan eh. Panalo ka ng kalahati, panalo siya ng kalahati. Pareho kayo nanalo, kaya lang half-win lang yun. Pero kung win-win ang mangyayari because of the approach of this type of leader, mas maganda ang kalalabasan ng meeting. That's my take on that. What do you think, Martina?
All right. Before I start, I would like to first greet our early birds. We now have over 150 people who are watching live
Wow!
at today's HR Cafe. I expect it to double kasi po sobrang init po ang topic ngayon at sobrang galing po ng ating guest
Ating
speaker. So let us first greet those who are the early birds. Ma'am Ana, so these are the early birds. So sabi po, Sel Ann Gulapa Lapua greets everyone. Good afternoon. Joey Albert Lamita is watching from Taguig. Zarina Halos Villavicencio says she is watching from Lipa, Batangas. Good afternoon. Flor Diaz is watching from LNC. Carol Velo watching from Quezon City. Cherry Burgos Morato watching from Bulacan. Helen Halili Gonzalez. Annalyn Barshal Romulo. JP Kaalim and Lowell Mabolo greets everyone. Hello. Somes is watching from Iloilo City. Lori Jane Ricablanca Lanohan has tagged her friend Johan Delphine. Zain Lejano says, good afternoon. We have Irish giving a heart mark. Jonas Gulye Olandria, Irish. And Jonas Gulya is watching from Taytay, Rizal. So we have a lot of people who are greeting everyone a very happy day. Good afternoon. Maria Cristina Marta Bautista is watching from the city of San Fernando, Pampanga. So as you can see, kahit na magnood ng HR Cafe, para tayo nagkakaroon ng geography lesson sa Pilipinas kasi galing po sa dami-daming mga lokasyon ng ating mga viewers. We have
Mm.
global trainer Jamie. Sabi po ni Ma'am Janie, a genuine leader determines what will be best for the company and many, even if others initially may not agree, but a true leader can inspiringly impart and explain another angle of the situation that can enlighten others to collaborate and contribute freely. Ito po yung sinabi ni a leader is a great navigator. They have a big picture view of situations and are able to create a new path for those whose ideas contribute. So at as we can see,
Galing.
ang dami
Very
pong
good.
mga nagko-comment po tungkol
Very
sa
good.
wow quote of the week.
Mhm.
There we go. So sa akin naman po, a lot of people think that collaboration is important when looking for a company to work for. 'Di ba? Maraming mga employees nagsasabi palagi, I want a boss who listens to my input and takes my opinion into consideration. And that might be great in cases where the company is stable. Ako kasi po, nagsa-start ako ng isang company and I realized the importance that the leader not only listens to his subordinates, but the leader's role is also to set the general direction, the standard rules and regulation that everybody in the company has to follow. Kasi for example, 'di ba, marami pong kasi nagsasabi, gusto ko kasi makinig palagi sa akin ng boss ko. Now imagine yourself in a company with 100 people. With 100 people with their own beliefs and ideas, of course you will have 100 different opinions on where the company should be. Ask 10 people what they want for the company, what type of benefits they would give for the company. And of course, everybody will say either more pay, more benefits, more HMO. Iba-iba po ang importante sa bawat empleyado ng company. So it's really difficult to get consensus. When we say consensus, it means that everybody agrees on the general direction or decision that the company must partake going forward. And we all know sa mga leaders na gumagawa ng desisyon, napakahirap po gumawa ng desisyon pag masyadong maraming input na nanggagaling sa iba't ibang tao na kapaligiran natin. I feel that a genuine leader is not just somebody who listens to people's inputs. A genuine leader should actually listen to those inputs, collate them, and then decide for the benefit of everyone what is the best decision to make, even if it is not the most popular decision for everyone. We are always trained to please other people. Ayaw nating magkaaway, gusto natin masayang lahat. But when you're going to war, when you're actually in a crisis, sometimes you can't win it all. May mga tao talaga na maaapakan, na hindi magiging masaya sa desisyon. Meron ka nang binigay na redundancy pay, dinagdagan mo na, siguradong meron pa ring taong hihingi ng mas malaki pang pera. Kasi for them, kulang yung binibigay natin. And that is the reason why it's very important that we actually have the labor code of the Philippines, the Bureau of Working Conditions Handbook, and of course, company rules and regulations that help regulate the business on what type of rules everyone has to follow going forward. Such documents are very important in making sure that every single person and the employee is treated fairly and follows the same rules and regulations so that the company can all move to the right direction. I think ang pinakamahirap sa isang kumpanya is when may nagbigay ng isang rule tapos hindi nasusunod yung rule na yon kasi favorite siya or malakas siya or may kapangyarihan siya. That is why today's topic is super important because in the absence of a strong leader, More often, it is the company rules and regulations that will set the direction of where everyone must follow, so that everyone has to have a certain set of standard operating procedure or disciplinary procedure to follow. And sa mga taong walang company rules and regulations kasi masyado po silang maliit, there is still the Philippine Labor Code, which is available for all. So sa mga taong nagrereklamong walang kontrata, walang rules and regulations ang company, don't fret. Meron po tayong labor code that protects both employers and employees, so that lahat ng tao pantay-pantay sa baba ng batas. So, 'di ba? So makinig tayo lahat. We're almost at 200 people. And right now, we would like to greet Jolina Okada Marapones from Mandaluyong, Siena Benedicio watching from Antipolo, Harry from Antipolo Rizal, Ann Limbo who's watching from Caloocan, Lizelle Evangelio who's watching from General Trias, Cavite, Eileen Yana Samson who is a micro entrepreneur from Antipolo, Ana Esposo who's watching from Subic Bay Freeport, JQ, Flor Diaz says, agree much, actively part of the solution, not creating more friction over collective consensus. June Aspacho is also watching and listening to his idol, attorney Alvin. Edison Andamo is watching from Las Piñas, and Jacqueline Trinidad and Chelsea Constante Odonso has greeted everyone. Good afternoon. Over to you, Sir Alan. Muted po, sir. Sir, mute.
Yon! Muted pala ako. HR question of the week. Ito, very timely yung question. Ma'am Tina, no? Sabi, I think this is a hot topic in the PHRG wall. Somebody asked this or shared this. We just hired an employee under probationary contract, no? But one of our clients pulled out and we no longer have a need for the role. Can we just end the probationary contract instead of paying for retrenchment due to authorized causes? Yun ang tanong niya. So, Ma'am Tina, you want to be the first here? O ako muna? Yeah, sige. Actually, ito yun, no? This is improper. You cannot simply terminate the probationary contract to avoid paying retrenchment due to authorized causes. While probationary periods exist to assess employee suitability, they cannot be misused to circumvent legally mandated compensation. Here's why. Unang-una, probationary period limits is one of the reasons. Philippine laws limit the probe period to a maximum of 180 days or 80 calendar days, no? The purpose is the purpose is to assess fitness for regular employment, not to avoid retrenchment obligations. All right? Klaro yun, no? Number two, termination during probation is another reason. During probation, both employer and employee can terminate the contract without notice or just cause. However, this only applies to situations unrelated to retrenchment or authorized causes. Third reason, retrenchment versus probationary end. Retrenchment occurs when an employer downsizes due to economic reasons or business closures. It requires following specific steps, including paying separation pay or 1 month salary per year of service. Ending probationary period or ending probationary contract is simply concluding the assessment period. It should not be used to disguise retrenchment due to economic reasons. Hindi niyo pwedeng i-convert or i-circumvent ang batas dito using that as an alibi. Kasi these are may mga potential uh, issues at problems yan. If the employee feels unfairly terminated to avoid retrenchment benefits, they can file a complaint with the DOLE. If DOLE finds the termination improper, your company may face penalties and be ordered to pay separation pay or damages. Kaya, ang recommendation, please analyze the situation honestly. If the client pull out genuinely necessitates workforce reduction, then retrenchment is the legal and ethical approach. Consult with a lawyer specializing in labor law. Huwag kayo manghuhula. They can advise on the specifics on your situations and guide you through a proper retrenchment process. Okay? So consider also alternative options like perhaps redeployment to other positions inside your company instead of just um, using the proby period as your alibi. Remember, prioritizing legal compliance and ethical treatment of employees protects your company from potential legal disputes and maintains positive employee relations, which is your role, which is our role in HR. So may disclaimer lang ako, yung pong aking opinion is for general guidance only and should not be considered as legal advice dahil hindi naman ako lawyer, no. Yan din po ay galing lang din sa aking kaibigang lawyer na lagi kong kinukonsulta pag meron ng mga problemang ganito sa aming kumpanya at sa aking mga kliyente. So please consult with your lawyer or qualified lawyer for specific legal advice regarding your situation. Back to you, Ma'am Tina.
Simple lang naman yung sagot, okay? So the separation pay of the Philippines is minimum of 1 month of pay. Right? So, kung kunyari magtatanggal kayo for retrenchment or redundancy and that person has served you for less than a year. So, for example, 3 months, 4 months, 5 months, 6 months, up to 1 year. Ang minimum na mababayaran mo, whether it's retrenchment or redundancy, is 1 month pay of salary. Now, let's assume that person is minimum wage. And dapat naman talaga sa budget mo, babayaran mo naman talaga yung tao na yun when you're going to hire that person, hindi po ba? Mas maliit po ang bayad ng separation pay than if that person actually goes to DOLE or NLRC and files a complaint for illegal termination. Kasi kahit na for example, probationary employee lang siya, 1 month lang siya, 2 months, 3 months, 4 months, 5 months, any employee in the Philippines still do have a right to actually file a labor complaint against you. And whether or not may kaso yung tao na yun or wala, DOLE will entertain that employee. Even if sinabi mo na wala siyang kaso. So a lot of our HRs kasi, we tend to interpret the law the way that favors us. And the
Mhm.
problem kasi is when you are terminating somebody because a client pulled out and you no longer have any need for the role, it does not fall in the stand on what is the valid reasons to end a probationary employment.
Mhm.
Kasi the rule of probationary employment is, number one, from the very beginning of their employment, dapat it's very clear for them ano yung standards for regularization. And these standards are usually attitude-based, performance-based, culture-based. It's not because wala naman nakasulat dyan pag nag-pull out yung client ko, wala ka ng trabaho.
Mm.
Right? That's not part of the contract of probationary employment. All right? So, if you're just going to make up rules on the fly because of some unexpected situation, kasi who wants naman the client to pull out, sasabihin ko sa inyo, mas murang magbayad ng separation pay of 1 month than to allow that person to complain sa DOLE. At pag nagreklamo na po yan, tumatakbo na po ang metro ninyo. At pag nanalo po yan ng illegal termination, ang babayaran po ninyo is
Kung isang buwan.
every month ng kanyang
Ah,
pagreklamo plus the separation pay, which is
yun.
1 month. Okay, so that is the reason why many illegal termination cases reaches a few 100,000 pesos kasi pahaba ng pahaba yung kaso, mas malaki ang binabayaran in terms of back wages ng company.
Mm.
Walang pakialam ang DOLE or ang
Mm.
batas kung nag-pull out ang client mo. Ang pakialam lang po nila is whether nasa tama ko po kayo sa batas or hindi. And unfortunately, a client pulling out and having no read for the rule is not one of the reasons for
Yeah,
ending a probationary contract kasi hindi
exactly.
naman siya masyadong performance-based, alright?
Mm.
So sa mga taong nanonood po sa atin, there is quite a few who's also watching sa ating HR Cafe. We have Reggie who's watching from Bataan, Marceline Villacruz Torno watching from Cebu City, Sherwin Gomez, greeting, good afternoon for all. We have Reina Durango de Pegran watching from Caloocan, Rosalyn Keith Villanueva who's watching via YouTube from Marikina City, Manuel Bebis watching from Camarines Sur, Bicol, Ghetto Jet Mercado watching from General Santos, Mary Ann Rezki, we have Christy Tiglao, Magandang Buhay for All. Polly Dodds is being tagged. We have Labron watching from Malate, Manila. James Lance Fornea watching from UP Campus. Christy Tiglao watching as is a motorcycle dealer from Marikina City. Matilde Fernandez Belen is joining from Iloilo City. Grace Oxtonal del Rosario is thankful for this session. So ito pa, if a client lang ang nawala and the company is still existing, should it not be considered as redundancy rather than retrenchment? Therefore, if it's redundancy, then probationary employees are not entitled to separation pay as only regular employees are entitled to separation pay. Correct? Hindi correct. Hindi correct. Hindi talaga correct. And that is the reason why so many employers are paying back wages pag nagreklamo yung employee na yon sa DOLE. So there we go. So Darwin says, probationary employees has the same rights as regular employment. All right? So very careful.
That's
Sabi
right.
niya, Attorney Joe Fernandez mother, thanks for watching. Hopefully we can guest you too,
Mm.
definitely. And now we move on
Hi,
to the
Ma'am
HR
Jo.
learning of the week. Job rotation, a management training technique that involves shifting a trainee from one function to another function to expand his or her experience and identify strong and weak points. Sir Alan, your experiences with job rotation?
Mm. Ang job rotation isang job redesign strategy yan. Pero pa nga tinatawag na job enlargement at saka job enrichment. Pero para hindi na ma-confuse, let me zero in on job rotation. It is actually a temporary assignment na binibigay ng company sa mga people involved in its department. For example, si dalawang employees, si Gina is in customer service. Si Joey is siya yung supervisor ng delivery. Para silang supervisor. So, hindi nila ma-appreciate yung trabaho ng isa't isa. Nag-criticize sila. Ang ginawa ni manager, nag-job rotation para ma-appreciate nila at maramdaman ang hirap ng kanya-kanyang trabaho. So, it's a temporary arrangement. This assigns employees or workers to an alternate job on a temporary basis, and it's useful for motivating in several ways. First, it provides the employees with something new to learn and do beyond their normal uh, tasks, no, and responsibilities. Second, it provides employees with a broader perspective on how the organization operates as a whole. Third, it increases the employee's understanding of what his or her coworkers do, which leads to higher degree of respect, empathy, compassion, and understanding of what others do rather than criticizing them. Wala namang ginagawa yan dito. Gagal ang trabaho niyan. Pag nasubukan mo, dahil ni-rotate kayo, doon mo na ma-appreciate ang hirap pala na ginagawa nila. When you go back now to your original work after the rotation, the temporary assignment, magkakaroon na kayo ng respect to each other. So, it offers an employee the chance to gain additional skills as well, which increases their value to the organization. So essentially, job rotation is a great strategy, no, for learning. Parang immersion yan sa loob ng department mo, no? Immersion for employees. And this will make them, in another reason, probably in extreme cases, everybody's flexible to do everybody's job. Pero huwag dating abusuhin yon. ginagawa lang yun kapag talagang extreme cases. Right? So unless if you want to laterally train the person para eventually when he becomes a supervisor, kung he is being, the person is being honed as a supervisor, alam niya yung mga iba't ibang facets of or iba't ibang tasks under that particular department. Alright? Yun po yung take ko dito sa job rotation. Ma'am Tina?
Sa akin naman po, if you have enjoyed long tenure in a company, there is a high possibility that your career will be changed and management will rotate you to several different roles about when business need arises. So for example, nag-start po kayo as encoder. Tapos nakita ng management, ay, what if for example, itong tao kailangan magtakbo sa maggawa ng permits. Or for example, dati HR ka, ikaw yung nag-i-interview. Management will ask you to maybe conduct training. Okay? And a lot of people are always saying na sa dami ng mga trabaho na binibigay sa akin ng management, what's really my right to refuse those roles? Especially since most of these roles and responsibility actually do not have extra pay. Yun lagi yung tanong, ang daming nang binigay sa aking trabaho, pero yung sweldo ko hindi po gumalaw, legal po ba yun? And I think we have to go back to the what is given what type of authority is given by the labor code to companies, which is they do have the right to recruit, trade, operate their businesses as they see fit. And I think if you are fortunate and unfortunate enough to stay in a company which gives you a lot of different work for the same amount of pay, you do have the right to actually state that you negotiate for a higher pay. And management has the right to actually give that to you or decline your request. So long as your pay is above the minimum rate that is set in the entire Philippines. Marami kasing taong nagtatampo na, "Uy, maliit yung sahod ko pero ang dami kong ginagawa, sobra akong overwork, sobra akong overstress. Legal ba na dahil nag-resign yung kasama ko, ibibigay sa akin yung trabaho niya pero hindi yung sahod ng tao na yung binigay sa akin?" And I think sa tanungin natin sa sarili natin is, well, if you're really that indispensable, maybe you should show management how indispensable you truly are. And that has happened because so many people have resigned and then pag alis nila, company will hire 2 to 3 people just to replace that role, right? So I think we need to look at, practically speaking, we do have the right to refuse. Actually, no, we do not really have that much leeway to refuse job rotation so long as it covers in the work-related aspect of the company. Siyempre, for example, pag inutusan kang kumuha ng labada, or inutusan kang gumawa ng mga pamasahe, pwede kang mag-refuse. But many companies hire people with a clause that says, and any other work-related tasks that may be assigned to you from time to time. So sa akin lang, if you are rotated, take it as an opportunity to prove to management you're worth that higher pay. You can negotiate for higher pay. But if management do not give you such higher pay, you have the right to actually resign and render X number of days notice to prove to them how indispensable you are. Pero pag wala pong humabol sa inyo, huwag tayo masyadong magsabing illegal yung ginawa ng management because that still falls under management prerogative. Alright? I hope it's very clear. Okay? Ako po, never po ako nagtanggi ng additional tasks and responsibilities and I have seen my salary increase dramatically over time. But that comes after proving to management that I can do the job and more. Right? So if you are indispensable, truly, management will pay for giving you additional roles. Kasi they realize, mahirap kang palitan. Pero pag hindi ka dinagdagan, wag po tayong magtampo. And we have two choices. Either we take it positively and as a learning opportunity, or find a company that gives you better work-life balance or higher pay. Kasi kung magaling ka naman sa dati mong company, mas madali ka naman makahanap sana ng mas magandang company that values work-life balance and does not tend to overwork you. So, as we say, may balanse pa rin sa Pilipinas no matter what. And with that, we will move to the update so that we can go for the second part of the show. Apparently, sa panukalang 100 pesos na dagdag sahod sa dole, nakahandang magbigay ng technical input sa Kongreso. So, mahigpit na binabantayan ng dole ang pag-usad ng Senate Bill number 2534 na nagmumungkahin na isabatas ang 100 pesos across the board wage increase ng buong bansa sa mga empleyado at manggagawa sa pribadong sektor. If this happens, it will no longer be 610 pesos per day. It will now be 710 pesos per day sa NCR. Pero po, hindi pa po, this is not a law yet. So, wag po tayong masyadong maging excited pa muna. Wag tayo
Oo.
masyadong don't quote the HR Cafe. Hindi pa po siya batas. Plano lang
Mm.
po siya sa Kongreso. Hindi pa siya approve. Wag na po muna kayong humingi ng 100 pesos na dagdag sahod kasi hindi pa po siya law. Pero I would like to comment on this a little bit to say na a lot of people who are employed might be happy about the 100 peso wage increase. So that's around 2,200 to 2,600 per month additional, hindi ba? Na nakakapagtulong sa pagbayad ng renta, correct? However, we also have to be conscious about the law of economics. Pag tinaas po ang price of labor or cost of labor, susunod din po ang cost of goods. So, tataas po yung sahod ng messenger na tagadala ng mga resibo ninyo from point A and point B. Siguro tataas din po ang presyo ng mga tinapay, pagkain, kasi po yung mga taong nagluluto, nagsaserve, sahod po nila tumaas ng, kunyari, meron kang 10, that's 20,000 pesos increase across the board. For sure, 1,000%, that 20,000 pesos, ibibigay po yan sa cost for consumer. So, tataas po ang presyo ng ating bilihin, pagkain, gasolina, driver, etc.
Ipapasa lang.
Lahat, ipapasa lang po ang additional increase ng 100 doon sa mga presyo ng goods and services.
Pero para sa akin, Ma'am Tina, alam mo, malaking tulong pa rin yun kung tutusin. And people will
Hindi na po,
find that they
hindi
will
po,
find
mm-mm.
they will find that helpful pa rin kasi they may find a way to alleviate their difficulties financially creatively kasi dagdag pa rin yun sa kanilang cash, no? No, paano mo maging impact niyan sa economics? Tanggap na yan ng mamamayang Pilipino eh. In fact, a lot of economic studies dapat hindi nga lang daw 700 daw, hindi lamang 100 ang dapat idagdag. Kaya lang, alam naman natin sa reality, because of the economic situation right now, hindi nga kakayanin. Pero there's a demand na sana naman para decent yung buhay, mas mataas-taas. So it's a tug-of-war talaga. It's a tug-of-war. And
Ang kawawa po, yung mga taong walang trabaho at taga-tambay, ang mga
yeah,
housewives, hindi na po kaya ng isang minimum wage employee na isuporta ang kanyang asawa na housewife lang po and kanyang 4 to 5 anak na nag-aaral sa public school. That is the reason why I've seen recent trends of females who has not worked for 10 years or more returning back to the workforce because both people need to work. Hindi na po kakayanin ng isang tao. Hindi katulad dati, si tatay lang nagtatrabaho tapos lahat hindi. May kapatid ka pang hindi nagtatrabaho. Ngayon po, lahat po ay dapat magtrabaho. And sa akin lang po, we might want to prepare in advance. Kasi pagdating ng panahon na lahat ng taong lalabas maghanap ng trabaho, mas magiging competitive po ang ating job market. Again, mas mahirap pong tanggalin ng mga taong matagal na sa trabaho versus sa mga taong kakasimula pa lang. So for me, I think we need to reassess our employment records, our resumes, and maybe get a head start kasi po tataas talaga po ang mga presyo ng lahat ng bilihin. And with that, Coach Oliver, welcome to the HR Cafe. Do you want to, after the
Hi,
Dole,
good
kayo na po yung
afternoon.
SSS? Oo. So, sa update po natin sa DOLE, meron again sa House Bill number 9931, an act granting heartbreak leave and providing emotional support resources for recovering employees. An employee age 25 years old and below can avail 1 day unpaid heartbreak leave per year, while those aged 25 to 35 years old can avail of 2 days of unpaid heartbreak leave annually. Again, hindi pa po siya batas.
If
Proposed lang
ever,
po siya.
paano mo mapapatunayan na heartbreak ang reason? Tapos wala kang jowa.
Ay,
Hindi.
magaling
Ah,
po yan.
Hindi,
Mm,
gawin nating requirement, isulat yung pangalan ng jowa, tatawagan ni HR. Just to
Yun.
confirm, naghiwalay na ba kayo?
yes. And with
Ang
that, Coach
tindi.
Oliver, your for SSS po.
All right. So for SSS advisory, e-wallet payments are temporarily unavailable in the SSS mobile. I think they are now upgrading the system because recently Android has also updated its version. So the mobile app is not yet available. This is also due to ongoing server maintenance. So I'm not sure if they're using premise or cloud based, but I suppose they have contingency plan for this, so for business continuity. So for the meantime, you can still call online or use online payment. Sorry. There are plenty of online payment options. You can do it through the banks, pay through your other e-wallets of any SSS accredited collection partners. So that's for SSS advisory.
All right. Next.
All right, and also for SSS revenue in 2023, it surpassed the target by 9.5%. So meaning dalawa lang po, maybe there are plenty of contributors, meaning new employees contributing to the system. And of course, they have also partnered with other organizations or collecting agency, which made it very efficient for all companies or most companies now to comply with the order. So as per SSS President and Chief Executive Officer Rolando Ledesma Makasaet said that the 362.2 billion revenue was the highest revenue so far attained by SSS. So it's good news for everybody, especially for those who are due for retirement, right? So perhaps we might be looking for an increase in the future.
Okay. Next.
All right, for pag-ibig, ako buwan ng puso ngayon, no? So ang pag-ibig na may loyalty. So you deserve all the rewards in the world as long as you have your pag-ibig ID with you. Now, another advisory coming from HDMF is what do you consider? It reminds all members to maximize our benefits through the use of Pag-ibig loyalty card and Pag-ibig loyalty plus cards with partner establishments. So bring that with you all the time. I mean, 10% or 15% discount could go a very long way. At least may pamasahe kayo pa uwi.
Mm. Sir, can we read the of Miss Jo Fernandez? Sabi ni Attorney Jo Fernandez commented dun sa ating HR learning kanina. Sabi po niya, stretch assignments have two implication. It can be a way to prepare successors, and it is considered a developmental assignment and there is continued guidance. However, there is a legal implication when an added role requires skills beyond current capabilities, so there is a lack of guidance and errors can be had far-reaching effects on the company and performance record of the employee. So in other words,
Agree.
okay lang mag-assign at mag-rotate, pero pag yung tao hindi alam yung ginagawa, siguradong mas malaki po ang balik at legal
Mm-mm.
repercussions ng isang company. Pag
Mm-mm.
mali po ang nilagay ninyong tao sa posisyon kasi rotate kayo ng rotate at ayaw ninyong mag-hire. Sir, pag-ibig, Sir Alan Cañete?
Pag-ibig pa rin ba? Araw ng
Yes po.
puso, kaya pag-ibig pa rin ang pinag-uusapan. Ah, nananawagan nag-a-announce po ang HDMF ng Pag-ibig uh, agency. Sabi nila, Pag-ibig Day with Family. So you can enjoy your membership at ito po ay um, yung mga merong Pag-ibig card, no? You can enjoy the benefits itong Pag-ibig loyalty card. plus partners, you can enjoy a 15% discount sa Enchanted Kingdom, 25% off naman sa ano tong WOF, and sa 30% sa time zone. So you
For
simply,
kids,
yes,
World of Fun, Enchanted Kingdom, and
world of
Time Zone.
fun. Yeah. You simply scan the QR code available
Mm,
in this ad. Tapos
mm,
pakita nyo lang yung inyong pag-ibig loyalty card to enjoy.
mm,
5% din pala sa Hapchan, 10% sa Figaro, and meron kayong free classic thin crust pizza from Shakey's. So yun po yung benefit ng pag-ibig. Kayong nagse-celebrate ng pag-ibig month. Now, para naman sa mga anunsyo mula sa PhilHealth, ang paborito din natin na government agency dahil sa kanilang pagtulong sa mga nangailangan ng healthcare, no? Sa araw ng mga puso or sa buwan ng mga puso, pwede nyo pong gamitin ang Z benefit packages para sa mga may karamdaman sa puso. Hindi po ito yung heartbreak na pinag-usapan kanina. Ito po, ito po ay talagang physical ailment, no? Yung merong coronary artery bypass graft or or rather CABG. That's 550,000 yung anyong benefit kapag ito yung natawag nilang standard risk. Meron ding 250,000 para sa ventricular septal defect in children or VSD. At meron ding 320,000 na benefit para sa mga tetralogy of Fallot or TOF sa mga bata. Siyempre, ayaw naman natin talaga magkaroon ng mga sakit ang mga mahal natin sa buhay, pero just in case lang na sa kasamaang palad nangyayari ito, nandyan po ang PhilHealth, atin po silang maasahan at para ma-contact po ninyo, meron po silang mga contact numbers at mga websites and social media accounts that you can get in touch with para makuha po itong mga benefits na ito. Another announcement from PhilHealth. There is a new 24/7 hotline mula po sa kanila at ito ay inaanunsyo sa lahat dahil lalo na kung pag emergency at kailangan nyo may makontak na personnel from them, just call the hotline. That's 24/7 and they are available 365 days a year. No weekends, no holidays. Kaya ready po silang tumulong. Ang number, hotline is siyempre 02, then 8662-2588. And they have 4 cell phone numbers in our ads now. And you can also find this in their website or even in their social media accounts para makuha nyo agad yung contact numbers na ito. Alright? So, that's from PhilHealth. Now, meron po kaming announcement dito sa Philippines HR Group. Again, we'll be launching our 2-day HR core training program. That's batch 5 here in Manila. And para sa mga curious kung ano ito, ang mga topics po ay total rewards, labor relations, talent acquisition, learning, and organization development. So this will happen on March 16 and 17 of the current year. That's a Saturday and Sunday, 8 a.m. to 5 p.m. And the venue will be on Discovery Suites, Manila, right there at the heart of Ortigas Center, Pasig City. So for the learning investment, just look at the posters, and I'm sure you can find it reasonable. Another announcement: um, Tech HR Singapore 2024 will be having a another event, and it is inviting everyone to join, and that will be the ang theme nila, ano, Build a Future Team 2024 conference at Bali. Building Brilliance, Crafting the Future Talent Landscape. That will happen on the 16th and 17th of October of the current year. That's a Wednesday and Thursday, right at Bali Nusa Dua Convention Center. Alright, so pag-ipunan nyo na to
Wow.
dahil napakagandang event nito. So, napag-usapan na nga po namin to sa board members ng PHRG, and we will be going there. And ang pangako ng grupo ay dapat kami buo. Mukhang hindi ko masisiguro kung kaya ba yan. Pero pipilitin ko makasama kasi maganda pong event ito. A learning opportunity and a networking opportunity. And meron pang isang announcement. Ay, ito na. Ito na po yung ating
Coach
event
Oliver?
for today. Go back to kay Sir Oliver. Sir Oliver.
Hello, thank you, Coach Alan, and thank you, Coach Tina, for letting me introduce our speaker this afternoon. It is my honor and pleasure to welcome our esteemed speaker for today, Attorney Alvin Alburo. Now, Attorney Alvin Alburo is one of the faculty at the University of the Philippines, Soler. Now, Soler is the School for Labor Relations and Labor and Industry Relations. So he's one of the faculty there. So I think moreover with Attorney Alvin Alburo's commitment to learning, he has completed his Master of Laws degree at San Beda College, if I'm not mistaken. Please feel free to correct me, Coach Tina, as I do not have his profile right now with me. But just a quick overview because I came across an event where I attended as one of the speakers alongside Attorney Alvin Alburo. So, sige po, Attorney, are you ready na po ba?
Ayun!
Ayun.
Attorney!
Okay.
Good afternoon po
Attorney,
and thank
welcome
you
Good
po.
for joining
afternoon.
us at the HR Cafe.
Okay, good afternoon, Alan. Good afternoon, Oliver and Tina. And to all of those persons watching your very good program.
We have
Yes,
about
sir.
300 viewers right now, and it's still going up, increasing po. Talagang very interested sila to learn.
Sir, we will be on the background. Do you have a PowerPoint or anything to upload or si Ma'am Ellie?
No PowerPoint, Tina.
Perfect.
I'll just talk. Mm.
All right. So we will be in the background. Sa mga taong nanonood, please, if you have any questions to attorney, you may leave it at the chat box, sa comment box po ninyo. So attorney, nakikita nyo po yung mga comments sa mga tao as they go along, di ba? So they can somewhat converse with you. And then later
Okay.
on, pagkatapos po ng PowerPoint, ng presentation ni attorney, we will go back for the Q&A. All right, attorney? Kayo na po,
Okay.
ha?
Okay. Okay, so once again, good afternoon, everyone. Okay. So after my talk, I will try to answer all your questions, no, if time would permit. If not, we are going to uh, limit the answering of questions to those most relevant and important questions. Okay. Article 3 of the Civil Code of the Philippines states, ignorance of the law excuses no one from compliance therewith. Now, aside from that, aside from knowing that ignorance of the law excuses no one from compliance, don't you think it's very important for us to know how should we interpret the law? Okay? Because we need to comply, no, with the law. And it's very important that we are guided on how laws are being interpreted, specifically labor laws. Article 4 of the Labor Code of the Philippines tells us that all doubts in the application or implementation as well as interpretation of the labor code as well as its implementing rules and regulations shall be resolved in favor of labor. Labor there means employee. Okay? Now, more on Article 4 of the Labor Code. The law starts with the phrase all doubts. The qualifier used for doubts is all, not some, not most of the, but all doubts, no? In the implementation as well as interpretation of the labor code and its implementing rules and regulations shall be resolved in favor of labor. So employers, HR personnel in particular, you have to take note of this. Okay? Now, if you do not want no doubts be interpreted in favor of the employee or employees, then what should you do? It is therefore important that your policies are clear, no? With special mention to your code of conduct, okay? Or your policy on discipline, no? Okay. Let's move on. Let us examine the anatomy of illegal dismissal. Okay? When we talk of illegal dismissal, it has two forms: actual and constructive. When you say actual, you told the employee, "Hoy, this is your last day. Ah. Tomorrow, don't report for work anymore because you are fired." That is actual, no? Illegal dismissal. But my friends, there is also another type of illegal dismissal. And we call and it is called constructive dismissal in Philippine law. Now, when you say constructive dismissal in layman's terms, it means that when you make the life of your employee so miserable, so unbearable, that the employee has no more choice but to quit his employment. And were it not for that unreasonable, unbearable treatment, the employee would not have quit his employment. That is constructive dismissal. Again, it is a form of illegal dismissal. Now, I'm addressing this to HR personnel. You have to be very careful with illegal dismissal because illegal dismissal is very expensive. Okay? Still, on the anatomy of illegal dismissal. When the labor arbiter, for instance, decided a particular case for illegal dismissal, and the labor arbiter said that there was illegal dismissal, do you know that under our present legal system, the labor arbiter is duty bound, no, to order the immediate reinstatement of the employee removed from service, okay, by the employer. Do not forget that. The order of reinstatement is immediately executory. Now, if, for instance, the employer would not want to obey the order of the labor arbiter, now, the opposing party, no, may file the necessary motion in order to have the employer cited for contempt. So the employer can go to jail because of not obeying, no, that particular order of the labor arbiter. And he or she will stay in jail for as long as he or she does not comply with the order of reinstatement. Now, question: what if you do not want to effect no, physical reinstatement on the employee. You do not want to put back the employee to his previous post. Do you have another option? Do you have an alternative option? Law says yes. No? In fact, Supreme Court, no, in support of the law, tells us, well, in that case, Mr. Employer, you do payroll reinstatement. So imagine, my friends, the employee is watching his favorite K-drama in his home, or perhaps he is traveling. No? He keeps on traveling from one place to another, enjoying life to the fullest. And while the employee is enjoying life to the fullest, the company is paying the employee on account of payroll reinstatement and during the pendency of the case. Let us clarify that. Oh, Pedro was dismissed from employment. Pedro questioned the dismissal before Dole. Okay. Labor arbiter decided in favor of Pedro. Labor arbiter said, there was really illegal dismissal. So, according to the arbiter, you have, Mr. Employer, reinstate Pedro to his previous post without loss of seniority rights. Okay? That is not discretionary on the part of the labor arbiter. The labor arbiter is really duty bound to make such an order if there is illegal dismissal. Now, if the employer says, but I do not want to see Pedro anymore, no? Whenever I see Pedro, I see 10 devils in his face. So, the employer has only one alternative choice, and that choice is to effect payroll reinstatement. Because, for instance, the employer filed an appeal questioning the decision of the labor arbiter. So the case is still pending, meaning the case has not yet reached its end. Because the employer has questioned the decision of the labor arbiter via appeal. So the case is still pending. But if you do not want to reinstate Pedro to his previous post without loss of seniority rights, payroll reinstatement is what you are mandated to do. And it will last for as long as the case is pending. Okay? Now, let's go a little further on illegal dismissal. So what if from the labor arbiter, it reached all the way up to the Supreme Court? And when the case reached the Supreme Court said, Pedro's dismissal was not illegal. Okay? Pedro's dismissal was not illegal. In other words, Supreme Court said the dismissal of Pedro was legal. So the question is, what happens now to those salaries you paid Pedro during the pendency of the case on account of payroll reinstatement? Because remember, Pedro was in your payroll while the case was running. So what are we going to do with those salaries? So in essence, Supreme Court said, thank you. You can no longer collect, you can no longer legally collect those salaries you paid Pedro during the pendency of the case, notwithstanding the fact that when the case reached the Supreme Court said that the dismissal of Pedro was legal. Okay? So imagine how expensive having a labor case is. On top of that, if there is a finding, by the way, of illegal dismissal, the employer is also duty bound to pay what? Back wages. And when you say back wages, it is computed from the time that salary was withheld from the employee up to the time of actual reinstatement of the employee. That is the computation guide, no? When we talk about back wages. So it's really very expensive, no, to have uh, an illegal dismissal case. And remember that back wages is only one among the items that the employee, no, sorry, the employer is duty bound, no, to pay the separated employee or the dismissed employee. So this afternoon, notwithstanding our very limited time, I'm going to introduce to you or to share with you the legal framework within which you must operate in order to avoid illegal dismissal cases. Or if an illegal dismissal case was filed against your company, there is, well, a substantial chance, no, that you are going to win. Okay? If you are the employer. My friends, due process, no, is a right. When we say right to due process, it simply means that before you punish a person, you must hear his side first. Okay? Now, when we talk about disciplinary process, no, with regard to employees, employers are duty bound to observe due process. So, in essence, before you discipline an employee, more so before you uh, decide for dismissing, no, that employee, you must, at the very least, hear his side first. Okay? Now, when we talk about due process, my friends, due process has two kinds pertaining to the disciplinary process on employees. What are the two kinds of due process? Substantive due process and procedural due process. Friends, when you say substantive due process, it simply means that before you discipline an employee, more so, before you dismiss the employee, there must be a reason supported by law, okay, why you are punishing that employee. So, in essence, that is substantive due process. There must be a reason, no, why uh, you are putting that particular employee under the disciplinary process of the company. Okay? Now, it is not only substantive due process that you need to comply with. You also need to comply with the other type of due process. And that due process is called procedural due process, meaning you comply with the legal procedure before you may terminate the employment of an employee. When we talk about procedural due process, my friends, you must adhere with the so-called twin notice rule. Okay? When you say twin notice rule, we are pertaining to notice to explain, first notice, and your second notice is notice of decision. Now, Supreme Court, in a plethora of cases, used the term notice of termination. Notice of termination and notice of termination and um, second notice or notice of decision the same. Okay? But I strongly suggest that instead of using the term notice of termination, you use the term notice of decision. Okay? It's more neutral, no? Uh, And why is it that I am suggesting that you use notice of decision? And I'm sure many of you are using this kind of notice because, well, it is not always the case that after investigation, the results of the investigation would warrant the dismissal of the employee from employment. You see? So notice of decision, I think, uh, is more proper to use. Now, let's go very quickly to substantive due process, the reason behind the removal from service of the employee. Again, the reason for the removal from service of the employee must be supported by law. Attorney Alburo, is it necessary that we must have a company code of conduct before we can discipline an employee? The answer to that question is no. No? So even if you do not have a code of conduct, you may discipline an employee. So you may ask, what therefore could we use as basis, no, to discipline an employee, which may include removing him from service? My friends, it's Article 297 of the Labor Code of the Philippines. So Article 297, no, enumerates the just causes for termination of employment. What are these just causes for termination of employment, my friends? Paragraph A of 297 talks about serious misconduct. No? That's the first part of paragraph A of Article 297 of the Labor Code. The second part of Article 297, paragraph A, is willful disobedience, no, by the employee of the lawful orders of his employer. We commonly call it insubordination. Okay? Please take note, my friends, that misconduct under paragraph A of 297 has been qualified by law. It is not just any form of misconduct that would merit dismissal. The misconduct must be serious in nature in order for it to merit dismissal. Okay? Now, as regards willful disobedience, please take note that the order disobeyed by the employee must be legal. No? Must the requirements, no? The requirements in order for willful disobedience, no, to be a proper reason or justification for dismissing an employee from employment, the order must be legal. The order must be reasonable. The order must be connected with the employee's duty. Oh, and how you may ask, attorney, we have this job description, no, in our company. And the last paragraph in our of the job description template in our company that is applicable to all our employees, there is that provision, and such other tasks that may be assigned from time to time? O question, no? What is the anatomy of that particular provision in the job description? Supreme Court has butchered that particular provision. Supreme Court said in essence, you cannot apply or invoke that particular provision, such other tasks that may be assigned from time to time, to such any other tasks. Practically all tasks. That if the employee says, I'm sorry, but I'm not going to obey that particular task you are giving me, you would immediately invoke, that's willful disobedience. That is insubordination, because here is your JD, and your JD is very clear. Your JD says, and such other tasks that may be assigned from time to time. So please take note, huh? Oh. Now, by way of exception, that particular statement, and even in the absence of that statement in the job description, when can you require an employee to perform a task or to do a task that is not listed in his job description? When? Well, according to the court, if the task at hand is intimately related to his core functions. So, for example, you ask the employee, your payroll staff, Oy, can you please uh, include among your submissions to me daily attendance report of our employees? And then the staff said, Boss, where in my job description does that particular instruction fall? No? In that particular scenario, you may insist that the employee must perform the task even if the task is not listed in the job description. And in fact, you may discipline that employee on account of insubordination. Why? Because though the task is not listed in the job description of the employee, that particular task is intimately related to the core function of the employee. Of course, attendance is relevant, very relevant to payroll, no? Oh, and the answer, and the reason for that is obvious, no? Now, letter B of 297 of the Labor Code is about gross and habitual neglect of duty. No? Now, please take note that the law uses the word "and," gross and habitual neglect of duties. Now, let me focus on habitual, the word habitual. Because gross is self-explanatory, no? Malala. How about the word habitual? Paulit-ulit, no? Here is a very clear and convincing evidence that HR, employers actually, must make sure that you have a very good documentation system. Why? Or let me ask you this question. How can you prove habituality? How can you prove that the employee violated this particular provision of the code of conduct repeatedly? How could you prove that if you do not have sound documentation system in your company? Worse, you are doing everything in your company verbal, including disciplinary matters. You do not have the relevant memos. You see? So the importance of documentation, my friends. Letter C, paragraph C of 297 of the Labor Code talks about fraud or willful breach of trust, no, by the employee. Please take note, my friends, that here fraud, willful breach of trust must be related to the official functions of the employee. So if you're a manager and uh, you have a very trusted subordinate, and on account of your trust to that subordinate, you disclosed personal matters, no? Your personal secrets, your deepest secrets, no, to that particular subordinate of yours, and later on, no, much to your dismay, that employee shared it to everyone in the company. Okay? In that case, my friends, please take note that no matter how angry you are, no matter how disgusted you are of the behavior exhibited by your subordinate, you may not use willful breach of trust as a ground for dismissal. Why? Because that willful breach of trust is not connected with the job of the employee. Your employee, unless you can show to us that included in his job description is to be a keeper of your secrets. So if that is not there, so it is not included in his job to keep your secrets. Okay? Now, paragraph D of Article 297 of the Labor Code talks about crimes committed against the person of the employer, any member of his immediate family, or any authorized representative of the employer. When you say authorized representative of the employer, we are talking here of managers, supervisors, senior staff, no, who have been given authority by the company, no, to direct, supervise, manage people. Okay. Letter E of Article 297 of the Labor Code talks about analogous cases. When you say analogous cases, any of the foregoing cases mentioned, no? A, B, C, and D, which I already mentioned to you. Now, a favorite question in uh, among the members in PHRG. Can you discipline, more so dismiss, no? Let's be more specific. Can you dismiss from employment an employee who committed dishonesty as regards the reason for his leave of absence? Oh, no? Supreme Court answered that question in HSBC versus NLRC and Meneses. Okay. You know HSBC, no? It's a very prominent bank. Hong Kong Shanghai Banking Corporation, no? But do you know what happened in this case? Oh, listen, huh? Meneses one day told his superior that he wants to go on leave. Okay? And the reason why he wants to go on leave because he feels sick. No? He is sick, according to him. Now, to be more specific, no, he cited as reason um, stomach ache. No, well, at the inception, his superior did not allow him to go on leave, but nevertheless, Meneses prevailed, so he went on leave. No? And upon his return for work, he presented, no, the statement that, you know, he went, in fact, to see a certain doctor named Dr. Logos. No? But do you know, the bank actually made an inquiry without the knowledge of Meneses. And to cut the long story short, it was proven that Meneses actually did not go, no, to see that certain Dr. Logos as regards the illness, no, that he mentioned, reason for his absence. And so the bank consequently, no, terminated him from employment. The bank cited as reason for his termination that particular provision in its code of conduct, in its employee handbook, which says any form of dishonesty punishable by dismissal. You see, my friends, any form of dishonesty, as stated in HSBC's employee handbook. That was the cited reason for the dismissal of Meneses. You know, the case went all the way up to the Supreme Court. And you know what did the Supreme Court say? Hmm? Supreme Court said, oh, well, there was dishonesty. But that dishonesty, as the reason for his absence, was not so grave to have resulted to prejudice of the bank. So it did not prejudice the bank, according to the court. So while it is true, there was dishonesty as to the reason cited by Meneses for his absence. But again, that dishonesty was not so serious, was not so grave. And in fact, the bank was not prejudiced, no, by reason of that dishonesty. And so according to the Supreme Court, that act, that act was a dishonest conduct on the part of Meneses, it should not have merited the penalty, the supreme penalty of dismissal. So according to the court, meting dismissal as penalty for that kind of dishonesty, hiding the true reason for one's absence. In fact, lying, no, for the reason of one's absence from work, according to the court, the penalty of dismissal is too harsh, too severe, too unreasonable under those circumstances. So take note of this, even though I do not, you know, I, I couldn't really type fast in my smartphone. Okay, so more often than not, in fact, not once, twice, or thrice that I saw people, I saw a question, no, relevant to that particular matter that I just discussed with you. Person, no, an employee lied, no, as regards the reason for his absence. Be very careful with that, because you already have the case of HSVC versus NLRC and Meneses, wherein the Supreme Court sided with the employee. Okay? Now, we are done with the just causes, no, for termination of employment. Let us go, no, to the other kind of substantive due process, because there are two kinds of substantive due process. You have just causes for termination of employment, which I just gave you a quick rundown. The other kind, authorized causes for termination of employment. Now, my friends, when we talk about just causes for termination of employment, as a general rule, employees removed on account of just cause is not entitled to separation pay. Do not forget that, Because when we talk about just causes for termination of employment, which I already enumerated to you, Article 297, A, B, C, D, E, what did you notice? I'm sure you noticed that the employee is either at fault or negligent. No? But when we talk about authorized causes for termination of employment, as a general rule, as a general rule, meaning there are exceptions. As a general rule, employees removed on account of authorized cause is entitled to separation pay. Why? Because an employee may be removed from service even if he is a model employee. Even if that particular employee, through the years, was able to collect so many awards pertaining to good performance. Nevertheless, the employee may be removed from service. As you can see, my friends, when we talk about authorized causes for termination of employment, fault, negligence of the employee, these are irrelevant. The employee may be a model employee, may be an angel kind of employee. But, nevertheless, the company may let go of his services on account of authorized cause. So question, what are these authorized causes for termination of employment? My friends, you can find these authorized causes for termination of employment under Article 298 of the Labor Code. And as regards disease, Article 299 of the Labor Code. Now, what are these authorized causes for termination of employment, my friends? You have installation of labor-saving devices, retrenchment, redundancy, closure of business, you have disease. Now, let's have a very quick rundown on these authorized causes. Installation of labor-saving devices. Or you are an owner of a manufacturing company, perhaps situated in Valenzuela. So you decided to have your vacation in Germany. And while you were having your vacation in Germany, you visited different plants there in Germany, that manufacture machines, that are applicable to your line of business. So to cut the long story short, you purchased certain types of machines, from Germany. You have those machines installed in your plant in Valenzuela. And on account thereof, before, you needed 300 employees in your production department. But on account of the installation of those machineries, you only need 100 employees in your production department. Take note, my friends, that law does not require you to keep all those 300 employees, even if in truth and in fact, on account of the installation of those labor-saving devices, you only need 100, making those 200 other employees not necessary anymore. So you may let go of these employees on account of installation of labor-saving devices. Make sure that you comply, huh, with the requirement that there must be a reasonable criteria that you must have used in choosing who are those 200 employees who must leave the company. There must be reasonable criteria. Do not forget that. Now, you're asking, Oy, Attorney Alburo, I'm thinking now, but I couldn't really imagine or think of a particular set of criteria that I may use, no, in deciding who must go first, no? If I am going to terminate the employment of some of my employees. Well, you may make use of a particular system, no, introduced by the Supreme Court. In fact, you can find this in a plethora of cases. The last in, first out rule, or the LIFO rule. Please take note, my friends, you are not duty bound to follow this particular system. Last in, first out. You may have your own system. But if you cannot find or you cannot think of a reasonable system that you can use in order to determine who must go, who must be terminated, who will be terminated from employment, then you may make use of the LIFO rule. Okay? Now, aside from that, you need to comply with the notice requirement. There are 2 notices required that you must comply. If you are the employer or you are the HR personnel acting for the benefit of the employer. 2 notices. Notice to the employees who will be affected and notice to the Department of Labor and Employment. As regards notice to the Department of Labor and Employment, they have this template that you can download from their website, which you need to accomplish, no, so that you can comply with the requirement, no, of notice to the Department of Labor and Employment. Please take note that you must comply with this notice requirement at least 30 days prior to the intended effectivity thereof. Intended effectivity of the removal from service of the subject employees. Okay? Do not forget that, Notice to the employees to be affected, plus notice to the Department of Labor and Employment using their prescribed template at least 30 days prior to the effectivity of the termination of employment. Do not forget that. Okay? Now, from installation of labor-saving devices, we go to redundancy. So, when are you going to use redundancy? No? Redundancy, in essence, is the authorized cause that you are going to use to remove employees from employment in your business on account of the fact that you have more employees than what you only need. And can we give an example of reason why is it that you have more employees than what you only need? Oh, For instance, you abolished certain positions in your company. After careful studying the need for personnel, no, and with good faith, you have discovered, no, that you have positions in your company that you don't actually need. So on account of those findings, you have decided to abolish these positions. So where are you going to put those people? Huh? So you have more people than what you only need. Oh. So you may redundate those people. Okay? So comply with the requirement for reasonable criteria. No? Comply with the requirement for notices, as I have mentioned in the previous authorized cause. Okay? Hmm. So from redundancy, let's go to retrenchment. Okay? In retrenchment, reason for retrenchment, serious financial losses. Or, you know, the the when we talk about financial losses, serious financial losses, if you are not yet experiencing it, it is already so imminent. So in such case, no, so you need what? If you want to save the company, no, you have to guard, no, your cash flow. And we all know that when we talk about expenses, one among the uh, expensive, no, expenses of a business or almost any business, expenses on employees, no, salaries, benefits, no, of these employees. So you are allowed by law, no, to reduce your manpower. No, you are allowed by law to let go some of your employees. So in such case, it is retrenchment. Okay? So comply, with reasonable criteria in determining who are the people you are going to retrench. Okay? And of course, comply with the two notices. No? Notice to the people to be affected, notice to the Department of Labor and Employment using their prescribed form at least 30 days prior to the effectivity. Okay? Next, closure of business. Well, law does not compel any one of us to have a business. So law does not also compel any one of us to stay in business. Okay? In fact, it is wrong to assume that businesses close only on account of failure, no? Specifically financial failure. That's wrong to assume that way. In fact, you know, one among our clients here in our firm, whom we have already established personal relationship with, this old couple, no? The husband and the wife, they have their 3 children, all professionals, a medical doctor, an accountant, and an engineer. Now, the business of this couple, export of various types of decorations made of indigenous materials. Okay? But, well, much to their disappointment, no one among their 3 children would want to join, no, in the company. And so the couple, no, considering the fact that they are already of advanced age. No? So they decided to close the company. Oh, you see? So that is an example wherein to show to you that there is closure of business even if there is no uh, financial losses on the part of the business. In fact, the business, no, was thriving. No, nevertheless, the old couple, decided to close the business. Okay, see, so closure of business, that is also an authorized cause. So in such type of closure, it is subject to payment of separation pay. Okay, installation of labor-saving devices, redundancy, retrenchment, closure of business, no, not on account of financial losses, subject to payment of separation pay. Okay? Oh. The amount of separation pay for installation of labor-saving devices, no? 1 month pay per year of service. When we talk about retrenchment, it's half-month pay per year of service. By the way, when you compute the amount of separation pay, a fraction of 6 months by law is considered as 1 whole year. Okay? So do not forget that, huh? Oh. Another type of authorized cause is disease. No? You can find that under Article 299 of the Labor Code. Now, when we talk about disease, my friends, you must read Article 299 of the Labor Code hand in hand with the relevant provisions under the IRR, or the Implementing Rules and Regulations of the Labor Code. When we talk about the IRR, no, make sure that you must comply with the requirements before you can terminate an employee on account of disease. No, by the way, it's any disease, no? But the point is the disease poses risk, no, to the person of the employee or to his co-employees. Okay? The disease cannot be treated within 6 months, even with proper medical treatment, as certified by a competent public authority. So please take note of that. Huh? The rule is very clear. Competent public authority. So you cannot just get a certification that Pedro can be terminated from employment on account of, well, you have placed there the part included in the certification is the type of disease, because according to the certification, it cannot be cured within 6 months, even with proper treatment. If the doctor who signed the certification is, for instance, a doctor from St. Luke's, or from Medical City, no, we know that these hospitals are private institutions, no. So please take note, the public, the one who must do the certification, no, that the disease is incurable within 6 months, even with proper treatment, must be a competent public health authority. Do not forget that. Okay? So, there you are. You have, under substantive due process, you have two types, no, of substantive due process. Either just causes for termination of employment or authorized causes for termination of employment. So, in order to be able to comply with the due process requirement of the law, you must have in your checklist, substantive due process and procedural due process. When we talk about substantive due process, it must either be on account of a just cause or an account of an authorized cause. Now, that's not enough. You must also comply with procedural due process. And procedural due process necessitates compliance with the twin notice rule. It is called twin notice rule because there are two notices involved. As mentioned earlier, you have notice to explain and you have notice of decision. Make sure that your notice to explain provides facts and circumstances leading you to believe that an infraction might have been committed. Okay? And specify that particular infraction right there, what particular section of your company code of conduct, and make sure, my friends, that if the imposable, not imposed, I said imposable. If the imposable penalty for the infraction allegedly committed by the employee is dismissal from employment, make sure that you give at least 5 days within which the employee must give his written explanation. Do not forget that. Okay. Now, the employee has already given his explanation. Okay? So, read carefully the explanation given by the employee. And then taking into consideration the relevant pieces of evidence that you have, then proceed to the notice of decision. So in your notice of decision, you must put there the relevant facts and circumstances, including the pieces of evidence that you have relied on, okay, which made you to decide that way. Okay, so for instance, you have decided for dismissal of the employee. So make sure that you have their facts and circumstances and the pieces of evidence that you have relied on, no, taking into all consideration also the explanation given by the employee and then why you have decided, no, to dismiss the employee. Okay, and then put there the effectivity date, no, of the dismissal. Now, my friends, in serving the notice to explain, in serving the notice of decision to the employee, any of these notices the employee refused to accept or to receive the notice, please do not fight or do not engage in a fight with that employee. No, it's worthless. Because in the first place, you are not required to force that employee to receive the notice. Okay? So if, for instance, the employee doesn't want to receive the notice, my recommendation, have at least 2 witnesses with you. And then write on the face of the notice when this notice or when this memorandum was being served to Juan de la Cruz on the date at around the time, no, Mr. de la Cruz refused to receive it. Period. Then the respective names of your witnesses with their corresponding signatures, date, and time they signed on the face of the document. That would already be enough. Okay, now you have this procedural due process already. Last item that I'm going to discuss before I end. No? When we talk about suspension, We have this so-called regular suspension and preventive suspension. I call the other one regular suspension because it's a penalty. No? Oh. So for instance, on account of the infraction, by way of punishment, the person is put under suspension. That is what I call a regular suspension. But take note, there is another type of suspension, which is actually a tool, no, that is available for employers, which is called preventive suspension. Remember that preventive suspension is not a penalty. It's not a penalty. But preventive suspension is an available tool to the employer. And when can the employer use preventive suspension? When the continuing presence of the employee in the workplace poses imminent threat, no, to life or property of his co-employees or of the employer. That's the ground, no, in order for preventive suspension to be proper. Okay? Now, is there a particular period, no, for preventive suspension? The answer is yes. Under the rules, it's 30 days. Okay? So, question. During preventive suspension, do you have to pay your employee salaries? The answer, his salary? The answer is no. No need. No? No work, no pay applies. Do not forget that. Now, let us vary the facts. Still on preventive suspension. Huh? Your audit head rushed to your office, told you, hey, boss, you know, there are so many records that we need to check. And after discussion with my staff, we have come to this conclusion that we need more than 30 days. In fact, we need 45 days to finish our investigation. So, boss, we need 15 days extension to that original 30 days preventive suspension period that you meted on Juan de la Cruz, boss, so that we can finish our investigation completely. Now, question, can you place that particular employee under preventive suspension beyond 30 days? In this example, for 45 days? Yes. Yes. Many would say no, huh? But the answer is yes. But under the rules, you need to pay the employee, no, in excess of the 30-day period. Oh, do not forget that, huh? Oh. So 45 days, huh? 45 days. No work, no pay applies to the 30 days, but to the 15 days in excess of the 30 days, pay the employee. Last point on preventive suspension, let us vary the facts. After investigation, it was found out, no, that Mr. Juan de la Cruz is not really at fault. No, he did not commit the infraction as alleged, for instance, in the MTE. Under those circumstances, my friends, you have to pay Mr. Juan de la Cruz salary corresponding to those days that he was under preventive suspension. Do not forget that. Many employers believe that for as long as they adhere with the 30-day period of preventive suspension, that even if after investigation it was found out that the employee is not really at fault, they believe that they are not duty bound to pay that particular employee for the 30-day period that he was under preventive suspension, because according to them, well, the employee was not working after all. No, no. You have to pay under the rules, the employee. Okay? for the period corresponding to the preventive suspension when it was found out that he was not really at fault. Okay? So, with that, my friends, no, I end my talk. And if you have questions, feel free to ask your questions.
Naka po, attorney, napakaganda ng talk mo. You're one of the few speakers that we have na hindi kailangan ng PowerPoint, pero napaka-impactful po ang ating mga points. We do have a lot of questions. So again, mga kababayan, kung may tanong po kayo, pakitanong lang po doon sa comment box. Attorney, ang daming nagtatanong tungkol sa case na sinabi po ninyo with regards to yung sa dishonesty sa HSBC. Alam naman po ninyo na magiging mainit na topic po yung sinabi po ninyo. Because so many people terminate on the basis of catching an employee being blatantly dishonest with the type of sa employment records po nila. 'Di ba? Pag kunyari sinabi nilang license sila pero sa totoo hindi naman totoo, or for example with sick leaves, yun marami yun na nahuli pala na nagbabakasyon or peke pala yung medical certificate. Could you actually give us a little bit more color as to why exactly natalo yung CHSBC given na malaking company, malaking budget for
Yeah.
lawyers? What happened po doon that
Okay.
made the Supreme Court decide
Oo.
that way?
Because, my friends, in that particular case, the
Mm.
bank cited their employee handbook. That particular provision in their employee handbook, any form of dishonesty punishable by the penalty of dismissal from employment. So they
Mm.
used that as reason, no?
Mm.
Because it was found out and there was really evidence that Meneses lied. No,
Mhm.
he lied when he said that he was sick. No, he was not.
Right.
In
Mm.
fact, he lied that he went to that particular Dr. Logos. It was
Mm.
found out
Mm.
after inquiry that he did not do so. But
Mm.
according to the Supreme Court, though there was dishonesty, the dishonesty was not serious, was not
Mm.
grave. And in
Mm.
fact, according to the court, that kind of dishonesty did not really prejudice, no, the bank. And so, according to the Supreme Court, the supreme penalty of
Mm.
dismissal is too harsh, too unreasonable a penalty to impose under those circumstances. Okay, so
Mm.
please take note, my friends. Supreme Court did not say that Meneses was not at fault. No, Supreme Court did not say that. In fact, Supreme Court said, yes, there was dishonesty, but dishonesty was not too serious, was not too grave to merit the supreme penalty of dismissal. Okay.
May tanong po dito, lalong-lalo na regarding to HSBC versus Meneses. Kung hindi dishonesty, pwede po bang loss of trust and confidence? I think this also relates to many companies dismissing managers for quote and
Okay.
unquote loss of trust and confidence. What are your thoughts about it? Kasi alam ko malaki ang butas ng paggamit ng loss of trust and kung hindi ka masaya sa manager mo, loss of trust and confidence. Pag yung manager mo, sinagot ka lang, loss and trust and confidence.
Okay.
You
In
know it,
fact,
you know it. Yes.
this is a very beautiful question, no? You know, when
Mm,
we talk about loss of trust and confidence as a ground for dismissal,
correct.
this is
Mm-mm.
my caution to employers,
Exactly.
I would invariably tell employers, it is very easy to dismiss a managerial
Mm,
employee than to dismiss a rank and file employee. And that's the
mm,
truth. Why? Because loss of trust and confidence is a ground for
mm,
dismissing a managerial employee. But
mm,
when we talk about rank and file employee, you cannot just use that ground no to any rank and file employee. The position of the rank and file employee must be a position involving trust and confidence. Examples, payroll staff, oh,
mm.
accounting staff,
Cashier.
uh, cashier, no? Favorite example of the Supreme Court, cashier. And then asset custodian. Now, these are
Yeah,
examples, no,
inventory.
of positions wherein, yes, they are not managerial, but involving trust and confidence. So you may remove them on account of loss and trust and confidence. But please take note of the caveat given by the court. Loss
Mm.
of trust and confidence is a conclusion of law. So if it is a conclusion of law, you must have facts to support that particular conclusion. So you cannot
Mm.
just dismiss Pedro from employment and just put in your memo, you are hereby dismissed on account of loss of trust and confidence. You must cite specific facts and circumstances, and of course, after observing due process, why you are led to believe that indeed, after investigation, uh, that particular ground is really an available justification to dismiss him from employment. Facts, there must
Mm.
be facts.
So, sa mga taong nagsusulat ng notice to explain, dapat merong who, what, where, when, why, and
Yes,
how. Hindi pwedeng generic notice to explain, which is sobrang hilig ng mga taga-HR. Hindi po ba yun, attorney? Pagbasa mo ng
brilliant.
mga NTE.
Brilliant. In fact, please, those who are watching this show, please remember what Miss Tina just mentioned. Those
Mm,
are the questions of a journalist. Those
mm,
are the questions you must answer, in the
mm.
notice to explain, so that your notice will be legally sound.
Sir, kanina po sinabi po ninyo regarding sa notice to explain na dapat nakasulat po lahat ng facts ng incident. But so many incidents at the point of occurrence have not a lot of facts available. So minsan, pagsulat po ng NTE, hindi pa po kompleto, which is why we have this question from our viewers. Sabi po niya, can the employer repeat the due process if there is an error siguro sa pagkagawa ng due process? Kunyari, nagsulat ng incident
Mm-mm.
report, tapos hindi pala yun yung nangyari, papalitan po yung NTE, which moves to the second question, can we modify the NTE? Terms in the letter of explanation. Kasi sometimes po when you're investigating, it seems eto nangyari, pero as you investigate 15 to 30 days later, hindi yun yung nangyari. Pero pagdating sa admin hearing, of course, you have to use the original NTEs and the second notice. Iba, mas marami pa palang information ang lumabas that might favor or not favor the employee.
Oo. The answer to that question is yes. And why yes?
Ah,
Because that's
pwede.
favorable to the employee. Oh,
Pag
that is
hindi naman
favorable to the
favorable,
employee.
nagdagdag ka pa ng kasalanan, alam mong nagnakaw lang ng 10,000, pag-imbestiga mo, 1,000,000 pala.
Just repeat the process, no? Just repeat the
Ah,
process. Oo. Why is it that there is no violation of the rights of the employee? Because in the first place,
oo.
under those circumstances, you have not imposed penalties yet. Oh, so
Hmm,
you can modify, no, the NTE, no, as but just make sure that you repeat the process. Or like for example, let us have a concrete illustrative example. You issued NTE to Pedro, okay, and you gave Pedro 5 days within which to explain
hmm,
his side, because the imposable
mm,
penalty is dismissal.
correct.
But on the third day, from the time that you gave that NTE to Pedro, you discovered some facts and circumstances
Additional.
not contained in the original NTE you served to Pedro. Question:
Mm,
can you give or issue to Pedro a modified NTE? Yes, no problem. Just make sure that you go back to day one. No? Oh, just make sure
hmm,
that when you issue that, you give the new NTE or the revised NTE,
mm,
just make sure that you give fresh period of 5 days
mm.
to the
May
employee.
nagtanong dati sa PHRG with regards to how long are the offenses erased? Kasi may mga companies na per year, back to zero. May mga companies naman, 10 years mo na ginawa, pagdating sa magta-terminate, yung 10 years na nangyari before na hindi mo na naulit, yun yung isa-cite nila. What's your opinion
Okay.
on that? No,
Okay.
kasi may ganun eh.
Oo. It is noteworthy that the labor code, no, does not actually prescribe for prescription with regard to infractions, no, committed by employees. Nevertheless, since it is for the benefit of the employee to have prescriptive period with regard to their infractions, then it is allowed. As regards to the length of period, it is submitted to the sound discretion of the management.
Mm. Okay, so okay lang kasi hindi automatic na dapat back to zero. Kahit na you reference what happened before, you can use it to build a case at least to sa NTE. Tama po ba yun?
Yes, actually. No, if there is a prescriptive period, follow the prescriptive period. Meaning, if the period has already lapsed, if for example, if the prescriptive period in your code of conduct is 2 years for this particular infraction, first commission of this infraction 3 years ago. So it's more than 2 years. So you go back to counting of zero, as if nothing was
Mm-mm.
done. If that
Mm-mm.
is in your company code of conduct, follow it. But remember, law does not require the employers to have prescriptive period with
Correct.
regard to these infractions. So you may choose not to have prescriptive period. That's okay.
Correct. Mm-mm. So it answers this question too. Do the sanction for employee violations like tardiness change yearly? Sabi ng manager ko na dapat back to zero ang mga violations yearly. Attorney, anong sasabihin natin to sa manager na nagnagalingan? Siya na magtayo ng company. Sir.
So again, no, it's really up to your company if you have prescriptive period. Again, there is no requirement for it to have its own prescriptive period. But my opinion is,
Mm-mm.
it is in keeping with social justice to have prescriptive periods for offenses. Why? Because remember that these disciplinary measures that we have in our companies are there to reform people. So it defeats the purpose of reforming people if you are always go back, or if you are always looking back to what he did in the past, even after 10 years ago. Okay? So that's my view.
Additional comment lang po dito. Please be very careful when when a manager gives an advice na in my previous company, in my personal opinion, yung mga dapat-dapat na yan, we have to take it with a grain of salt. Kasi hindi ibig sabihin yan ng opinion mo. Yan ng rule and regulation ng kumpanyang
Correct.
pinasukan mo.
Well said.
Hindi
Yes.
ibig sabihin na may vacation leaves ka dati na 30, dapat yung bago mong company 30 din kasi dati yun yung
Yes.
nakuha mo. So we have to be very careful again with the manager. I think these managers that said this is very irresponsible. Sir, parang ang dami kasing nagtatanong dun sa Meneses. Dapat po ba pag dishonesty first time suspension na lang muna para mas lalong kumapit yung termination later on.
There was this very beautiful statement. No, I am going to go back to this beautiful
Right.
statement mentioned by Tina a while ago.
Mm-mm.
She mentioned about those, for instance, employees who falsified, no, for example, in their application form, they said they have this license, but in fact, they do not have that professional license. No, let us take that as an example. So you have been hired by the company, okay? And in fact, in your application letter, you put there that you finished the course chemical engineering in, for example, in University of the Philippines, Los Baños, and that you passed the licensure examination. And the position for which you were hired, no? Let's make a crazy example just for people to understand. You are a secretary, for instance, of the general manager. Let's say it's a manufacturing
Okay.
plant. Oh.
Which is common kasi executive assistants are usually pag engineering ka, hinahire para sa position na yun.
Now, the pivotal question is this. Is being an engineer, is being a licensed engineer necessary for you to perform that job.
Mm.
That were it not for your license,
Mm.
you would not be hired by the company.
Mm.
If the answer to that is no, meaning your license is not relevant to your job, even if because you are hambog that you
Mhm.
put in your application form that you are a licensed chemical engineer, but in truth and in fact you are not, then you cannot be dismissed, no, from employment even if you committed a dishonest act because that is not related to your job. Oo.
For authorized causes, may nagtanong po, minsan kasi may naaaksidente na kasalanan po ng employee itself. And as a result, cannot perform again the physical requirements of the job. Can we terminate on the account of authorized causes, especially if it was actually due to the employee's negligence that they came into into that situation?
If because of that accident, for instance, the employee developed an illness and that
Mhm.
illness cannot be
Or a
treated with,
disability?
yes, with, it cannot be treated within 6 months as certified by a competent public health authority, and his continuing presence in the company poses either risk to himself or risk to co-employees, then he or she may be terminated on account of disease, which is an authorized cause.
With regards to eto, where do people draw the line on management prerogative? Kasi napakahilig ng HR and ng management to say company prerogative. In layman's terms, attorney, where should companies and employers draw the line?
Okay. So, while it is true that management prerogative is a right available to the employer, remember that this right is limited by the following: contract
Mm.
and law. So, do not forget that. You can
Mm.
actually add one to that: practice, company practice. Okay? So, do not
Mm.
forget that.
Sir, ito sobrang importanteng kasi update po yata to sa SC. Mark Santiago ask, Hi, Attorney Alvin. Is it required to conduct an admin hearing before terminating an employee? Thanks po.
Okay. So please take
Mm,
note that the Supreme Court, in a
yes.
plethora of cases, kept on saying, in fact, Supreme Court is like a broken record in saying that when we talk about when we talk about administrative disciplinary proceedings,
Mm,
hearing there is not limited to physical hearing.
mm,
Due
mm,
process requires hearing, but
mm,
hearing is not limited to physical hearing.
mhm,
Admin hearing is physical hearing. Okay.
mhm,
Nevertheless, according to the court, when you ask the employee to give his written explanation, no, that is actually in compliance already with the hearing requirement. Now,
mhm,
with respect to admin hearing, what
mhm,
is the rule? The rule is you conduct admin hearing under the following circumstances
mm,
if it is company practice. Oh.
mm,
Number two, if it is requested by the employee. And
mhm,
number three, if there is substantial evidentiary dispute. Sabi niya, pula, sabi mo blue, and there are pieces of evidence that are conflicting with each other, then under those circumstances, even if it is not your company practice, even if it is not requested by the employee, then conduct admin hearing only
mhm,
under those circumstances.
mhm,
Otherwise, as what Supreme Court would always say, hearing is not limited to physical hearing.
mhm. I think, attorney, ang magandang thread of thought is that if you assume that every person you terminate will file a labor complaint, ask yourself if you will do things differently. If
Yes.
you are confident that, ay, kahit na mag-labor yan, okay lang sa akin, magdole siya, I will still
Yes.
not change my process, then go
Yes.
ahead. You're confident eh. Pero
Yes, correct.
always assume na bago ka mag-terminate, basahin mo muna lahat ng mga documents na binigay mo sa employee. Kasi
Correct.
pagdating ng labor complaint, 'pag inakyat 'yan sa NLRC case, sigurado 1,000% kung anong sinulat mo, yun yung isusulat mo dun sa position paper mo. So you have to
Yes.
really judge for yourself how strong the language and the format you've made.
Yes.
Kasi
Yes.
people assume na sa dami ng na tine-terminate parang hindi naman magrereklamo. Eh, paano kung may nagreklamo? Right?
Yes.
So,
Yes.
change the way you think about things. Don't think na I'm following due process to terminate. It's more of if that person will file a labor complaint, will I do anything different? Will I write anything different? Will I do that admin hearing? And let that judge the way that you use it. Sir, parang yung sa probationary period naman po, sabi naman kasi, 'di ba, there's two trains of thought with probationary kasi sa 180 days. May mga
Mm-mm.
management na nagsasabi, ay probationary yan, wala pang 6 months, pwede nang tanggalin. O yan,
Mm-mm.
that's the first question. And the
Mm-mm.
second question is, na-evaluate ko na ng isang beses.
Mm-mm.
Pero hindi nag-agree yung staff sa evaluation ko. Kasi naman, pumapasok naman daw. Medyo
Mm-mm.
okay naman yung trabaho. Ano yung paraan? Pwede ko ba siyang matanggal if the
Okay.
staff will complain kasi he disagrees with that evaluation? How does an employer protect themselves properly?
Okay. Very good questions. Well, please take note, my friends, that the Supreme Court repeatedly said that when we talk about right to work of the employee,
Mm,
no,
mm,
it is not only applicable to regular employment. It
mm,
is also applicable even to probationary employees.
mm,
Okay? Now, law law's wisdom is this. Not all people are descendants of Einstein. Okay? Or let's operate within that wisdom of the law. Meaning, not all people are gifted with intelligence, no, brilliance that they can easily acclimatize with the demands of the job. There is a reason why the law gives 6 months, no, to the employee who is in probationary period to learn the intricacies of the job. Do not forget that there is a reason for that, and always remember what I just said. The assumption of the law is that we are not descendants, all of us are not descendants of Einstein. We have different capabilities. There are people who, if given enough time, to learn the intricacies of the job, would be able to contribute really for the benefit of the organization. So right to the work, specifically the term is the right to security of tenure, is not only applicable to regular employees. It is a right that is applicable also to probationary employees. But unlike regular employees, the right to security of tenure for probe employees is coextensive with the probationary period, which is 180 days. Okay, so don't forget that. That is very important. So for example, company XYZ no terminated Pedro because according to company XYZ, Pedro is not really good no in his job no. Pedro, according to that company, is not a fast learner. And so, after 2 months of working in the company, he was terminated from employment. Well, lucky for that company if Pedro did not go to Dole and question the termination. But if Pedro goes to Dole and question the termination, there is a strong possibility that Pedro may win because the right to security of tenure in that particular instance may be soundly alleged to have been violated by the company because
mm,
the company did not really give the 6 month period, which is the period the law thinks that the employee, ordinary mortals, would be able to learn the intricacies of the job.
mm,
Now, related question to that. So, does it mean that we cannot terminate an employee before the 180 period lapses?
mm,
No, we can terminate, but on account of just or authorized cause. on account of just or authorized cause, but not on account of failure to qualify for regularization, which is the common ground being used by many employers, because there is a reason for that 6 months.
Hmm. I think a good train of thought is sana yung mga HRs magaling magsulat. When you're going to terminate, as much as
Yes,
possible, you actually have to be very specific.
yes,
Don't just say this person is neglectful of their duties. You
yes.
actually have to specify what did this person do that would
Mm-mm.
signify that he is neglectful, and to
Yes.
actually ask that person to correct that behavior or that
Oo.
attitude on
Oo.
on your letter. Kasi
Yes.
the method of the letter is not as a way to justify termination, but it is to encourage the employee to actually stop the bad behavior or to
Mm-mm.
improve his performance, XYZ,
Mm-mm.
para
Yes.
ma-regularize siya. So, it's
Yes.
more positive than negative.
Mm-mm.
Kasi, the question is, pag nagdole na kasi yan, will your papers prove na
Mm-mm.
tatanggalin mo naman talaga yung
Mm-mm.
papel na kinuha mo is just a justification para
Mm-mm.
tanggalin mo? Or is there a genuine consideration to
Yes.
really regularize the person and give that person a chance to be employed properly?
Eh, and my friends do not.
Obvious eh,
Oh,
'di ba?
yes. And my friends do not forget, no? And as I mentioned earlier, that even prior to the 108, the lapse of the 180-day
Mm,
period, you have
mm,
two possible classes, no, of reasons you can get from, no, why you are terminating the employment of the employee, even
correct.
uh, f- far before the end of the 180-day period: authorized cause or just cause. For just cause, gross and habitual neglect of duty. That is,
Mm,
I think, a very pertinent just cause for termination of employment.
and there's a lot
Being a
of
probationary employee
does not
does not make you immune from Article 297, just
if
causes
the
for termination of
mm,
employment.
if the probationary employee is not really a good fit, you can surely justify it through your NTE. Kung wala kang masabi,
Yes.
may problema, hindi mo alam talaga may ano yung problema, sumusulat ka lang, wag gano'n. Nakakatakot yun.
Yes, yes, yes.
Dapat may alam
And
ka.
avoid writing as reason that you are dismissing that employee from employment on account of failure to meet regularization standards. And
Mm,
it is just the 50th day of the probe employee in your company. Tapos you
mm.
put there failure to meet regularization standards. Allah, that's very dangerous. You
Yeah.
might try to check the just causes, and I'm recommending you make, my dear friends, a serious look on paragraph B, gross and habitual neglect
Yan.
of duties. You
Eto
couch
sir,
your
yung
language according to that.
mm,
Ano.
pinaka-paborito ng mga employers, abandonment of work. If an
Mm-mm.
employee does not go to work for a couple of months and claiming he is still sick and cannot report to work but cannot provide any medical certificate to provide his claims, can the employer terminate his employment instead due to abandonment of work? Kaya,
Under un,
napakagandang tanong na to.
under these circumstances, yes, but you must have
Mm,
complied with the due process requirement. And yes,
mm.
abandonment is a terminable ground, but again, comply with the due process requirement.
Hindi ko nga maintindihan, attorney, kung nag-a-absence without leave at hindi na pumapasok ang mga tao, bakit hindi na pinapadalhan ng HR ng return to work order and inuutusan
Yes,
yung staff na bumalik sa trabaho para may konting kaso kayo na talagang may exert effort ka at may mali
yes,
yung employee at hindi ikaw. Kasi
yes.
later sasabihin ng employee, akala ko okay sa inyo na nagbabakasyon
Mm-mm.
ako. And I'm still employed, right?
Mm-mm.
So, 'pag
And
bumalik kasi
by
yung
the way,
employee oo,
why is it necessary? No, it must be emphasized. Why is it necessary that you must really issue or send a return to work notice to the employee? My
mm,
friends, you cannot find that return to work notice anywhere in the labor code, huh? But why
tama,
is it necessary for you to do that?
yes,
It's
mm,
because, remember, that in abandonment, in order for you to use it as a justification for termination of employment, one among the requirements is this: that there must be a proof of the employee's intent to abandon his work.
Mm,
So how are you
mm,
going to prove that intent to abandon his work? Use what Miss Tina said. Issue a return to work notice or a return to work order. No, that is a
mm,
very good evidence to show, no, that since your order remains unheeded, that the employee is indeed no longer interested, no, to perform his job, which
mm.
is abandonment. You must be able to
Attorney,
prove intent to abandon.
maganda 'tong tanong na 'to kasi sobrang lalo na nung COVID, there's a
Mm-mm.
lot of companies that were transferring employees from one place to the other because of business need. Tanong
Mm-mm.
po ni Ronald Lapos, what if the employee refuses to accept the transfer of office? Kasi dati daw isang sakay, ngayon tatlong sakay. It's nangyayari.
Okay. Mere inconvenience on the part of the
Mm,
employee is not a reason, no, in order for them to legally refuse the order of transfer. But please
mm,
take note, what are the parameters that must be met by the employer so that the transfer order would be considered valid? So if you are going to transfer your employee from one location to another location, make sure that your transfer order is in writing. Do not forget that. It
hmm.
is also within management prerogative to transfer the
Mm,
employee, when we talk about geography, anywhere in the Philippines as
mm,
needed by business exigencies. Do not forget that. That the employee should say yes is not relevant. But the
mm,
yes of the employee as regards the transfer order is necessary if the transfer pertains to a place outside the Philippines. But within Philippines,
hmm,
it is management prerogative and no need for the employee to agree, no, in order for that transfer to be valid. Just make sure that the transfer order is in writing. So therefore, a verbal transfer order may be validly refused by an employee. And when you discipline an employee on account of refusing your verbal transfer order, that suspension can be held illegal. Worse, if you terminated the employment of that employee, that termination may be considered illegal because the cause for the termination is wrong. So make sure that the order of transfer is in writing.
Sir, we have a lot of questions but we don't have a lot of time. So I think we should just read mga 2 to 3, maximum 3 na lang tapos first come first. Sir, how frequent should gross neglect be to be considered as habitual? To be
Okay.
safe, to be safe, 'di ba?
Oo. No,
Mm,
no hard and fast rule on that eh. So it really depends on the peculiarity of the act involved. It really depends on the peculiarity of the task and the needs of the company. But this is my point. If you are in doubt, always resolve the doubt in favor of the employee. So if you think that three, no, three times you think is may be considered insufficient, so you are in doubt, resolve that doubt in favor of the employee. The mere fact that you feel uh you feel not okay about it, no, you have some qualms about it, then increase, no, the frequency.
mm, So, usually ang ginagamit sa gross and habitual neglect of duty sometimes is dun sa latent absences. Kasi there's some people na laging late. Hindi nila
Mm-mm.
matigilan talaga araw-araw ma-late. So, ang dami mo
Mm-mm.
ng so nakasulat nga dito kay Sir JB, what about the probationary employee terminated because of latent absences? Sir, madali lang po yan.
Mm-mm.
I-memo mo na regarding doon.
Yes.
I-emphasize mo na kailangan siya maging on time. And
Yes.
then kung hindi niya kaya maging on time, really cite talaga na you really value attendance. Pero sir, I think when you make disciplinary actions like this, I think companies also have to be careful about making sure it's fair for all. Kasi
Yes.
minsan, pag nagta-transfer ng employee, yung pinag-iinitan lang, yung gusto lang tanggalin, yun lang yung padadala sa malayo. Pero yung
Ah,
iba, hindi tina-transfer. 'Di ba minsan may gano'n?
that's a very good point, no? That's a very good input,
Mm.
Tina. Oh, you do not do that, huh? Employers and HR personnel listening now, no? Do not do that because it's very dangerous. That may be considered as illegal dismissal on account of constructive dismissal. Okay.
Hmm. Ay ito nga yung sinasabi nga na sa company na may branches nationwide, sinasara ang branches, may mga gustong pa-move ng 100 kilometers or 2 to 3 hours away. Balik tayo dun sa sagot po ninyo, puwede bang mag-refuse si employee? Kasi talagang layo.
Well, in that particular case, that may already be considered as an exception, no? Because
Mhm.
what is the reason? In this instance, it may not only deal with the aspect of transfer, eh. It may already deal with the aspect of contract rules, no? Rules on contracts. We have law on contracts, eh. You cannot just modify the terms and conditions of the contract at will. Eh kung sobra ng layo naman talaga yung paglilipatan mo sa employee, no, talagang because of that, no, the expenses, no, of the employee will be doubled.
Boss.
Oo. You see, then under those circumstances, I would submit that the employee may reasonably object, no, to the order of transfer because it would already amount to modifying, no, the terms and conditions of the contract. Inano mo ako, nung hinire mo ako, kalinaw-linaw na ang place of assignment ko. For instance, nakasulat sa kontrata yung office mo dito sa Quezon City. Pagkatapos
Mm.
nilipat mo ako dun sa Tawi-Tawi. Oo.
Mm.
Tapos wala ka man lang bibigay sa akin na additional na pera para doon sa mga gastusin ko. You see?
Mm.
O,
I
lalo
think
na doon sa
people
displacement cost.
I think people have to be very careful on
Mm.
what is the reason behind the reason for termination.
Oo.
Kasi
Oo.
'pag sulat ng position paper, people will analyze talaga
Mm.
why you made that order.
Mm.
Is it really via business needs or is it a way to remove a union?
Yes.
May gano'n, 'di ba? Or to
Kaya ang laging test diyan, reasonableness. Test of
mm,
reasonableness. Pag ikaw yung HR o ikaw may-ari, tanggalin mo muna yung sarili mo dun sa sitwasyon. Kunwari iba kang tao, kunwari ikaw ay cold spectator, tingnan mo, reasonable ba? Pag medyo
mm,
merong kang qualms na mukhang hindi, resolve
mm.
that qualm in favor of the welfare of the employee. So yun para ka lang para maging safe yung action mo.
Sir Attorney, I will read to you the comments of some of our viewers ha. Sabi ni Benjamin Bulo, Manlapas Jr., sayang wala ng oras. Thank you, Attorney Alburo. Maki Porquez Torres says, thank you. Great talk. Thanks for all the information. Nice topic. Thank you for the info. So, kailangan ko pakita sa'yo, Zel Javier. Thank you, Attorney Alburo. Sabi po nito is very clear explanation for Article 297, 298, and 299 of the Labor Code. Nice talk, attorney. Very thorough, well understood. Good job. Thank you very much. Another insightful session. Tapos sabi po, management, tama ba to, Sir Attorney? True ba
Na
sabi ng owners, managers are not entitled or covered to due process kasi managerial daw?
wrong.
Nako, wrong. Probationary employees, contractual employees, regular employees, part-time employees, everyone is covered by due process.
Oo. Pati asawa.
Everyone.
Mm.
Everyone. 'Di ba? Huwag ka muna maghusga. Mag-imbestiga
Oo.
muna tayo, 'di ba? Hiwalay agad.
Oo.
Thank you, attorney. Tapos
Oo.
sabi po niya na thank you so much. So ang daming nagsasabi po, and sobrang dami nagsasabi, attorney. I think we're almost at the end of the show. I have to be very sensitive kasi Sunday is also family time for you. Attorney Alburo is one of the top labor, tama po yan? They specialize in labor cases.
Yes.
So if may companies need to engage attorney Alburo,
Oo.
how do they reach out to you?
Pwede nyo i-type yung Alburo Law. So, mahanap nyo na yon. Nandito lang kami sa New Manila. No? Along E. Rodriguez yung aming opisina. So, madali kaming mahanap. Nandun rin yung mga contact details. So, yung buong pangalan is Alburo, Alburo and Associates Law Offices. Pero pag tinype nyo Alburo Law, makahanap nyo na. Okay.
Tapos, attorney, paano naman yung mga taong feeling nila na illegal yung kanilang termination? Kaya, can they afford you?
To be frank, actually, no, talagang nandun naman ako talaga halos ang practice ko sa management side. Pero may mga pagkakataon talaga na pag hindi ko na masikmura at sa tingin ko kasula-sulasok naman yung ginawa ng employer sa empleyado, tinutulungan ko free of charge.
Pro bono.
Pro bono
Basta
yan.
malakas ang kaso,
Oo.
talagang may abuso.
Tsaka yung ano talaga, yung kita mong kinawawa na talaga. Ayan,
Oo.
hindi ko talaga yan nasisikmura. No? So, hindi ko yan pinababayad kahit na isang sentimo. Wala. Oo.
Attorney, is there any last words that you can regarding this topic and also how to for them that they can contact you?
Okay. In putting order to our businesses, we cannot really neglect the importance of discipline. But remember that the kind of discipline that we know perhaps inside our respective houses may not be applicable in our workplaces, specifically because of what the law requires. So make sure that you are abreast with the requirements of the law. Nevertheless, if you are in doubt, let kindness reign. Okay? May mga pagkakataon kasi na sinasabi ng empleyado, boss, alam ko naman talagang nagkamali ako eh. Sige na, pwede naman magre-resign na lang ako. Pero may mga boss talaga na yung vindictiveness talaga hindi nila makontrol eh. Hindi, hintayin mo, nababaan ka ng memo na talagang matanggal ka. May mga nagkaganon. Pag nakita ninyo yung tao, tumiklop na, nagsabi na, pwede bang hayaan na lang ako na umalis? Hindi naman sa idinidikta ko sa inyo yung pananaw ko, pero siguro you should have a second look. Baka pwede namang payagan na lang na mag-resign na lang siya kaysa sa tanggalin mo pa talaga. So again, if in doubt, be kind. Always choose to be kind. It will help you a long way to be kind. At by the way kayo, kung hindi ko alam kung recorded yung ginawa ng
Yes.
Soler na recent na online seminar at isa sa mga speakers doon ay si Tina. Talagang hanapin ninyo 'yon. Kailangan ako nung time na 'yon umalis, may kailangan akong puntahan pero dahil ewan ko ba naman at siya yung nilagay na last na speaker, siguro talagang intensyon nila na wag umalis yung mga tao dahil si Tina yung speaker. So talagang nag-stay ako sa bahay. So sana mahanap ninyo yon at mapanood ninyo yon. At Tina, saya-saya namin susuler na napanood namin yon. Yung mga ideas mo na napakagaganda.
Sana
Maraming
ma-invite
salamat.
po ako uli.
Maraming salamat. Sigurado yan. maraming
Sana
salamat.
ma-invite po ako uli kasi it's really a pleasure. UP is is my dream school. So for me, the last words lang po is number one, if you have any labor concerns, Attorney Alvin has already said that he is available for consultation. So you can either make an appointment with him through his Facebook page or contact his law firm through their Facebook pages so that you can avail. Ang specialty talaga po ni attorney is labor cases. Okay?
Yes.
The second one is, I think we have to, pag when we hire people, we hire them for a good reason. Ngayon, we should not let our emotions get in
Yes.
play when we're terminating somebody. Kasi I think a lot of the terminations is due to some personal anger.
Yes. Yes. Yes.
Nagrereklamo sa dole dahil din usually galit yung tao na yun sa company.
Yes.
Mabait ang Pilipino eh, hindi naman sila nagrereklamo.
Oo.
Nagrereklamo lang talaga pag may asaran na nangyayari.
Mm-mm.
And if you actually open position papers, we can see that those position papers that lose are usually those na obvious talaga na pinipersonal ng company yung employee na yun.
Yes.
Na from the very beginning, gusto na talagang i-terminate ng employer. Pero naghahanap na lang sila ng papel para ma-terminate yun. Kasi
Mm.
number one, etong tao lang 'to ang focus. Kung
Mm.
may nakawan, usually maraming involved, 'di ba?
Mm.
Ilan bang kinasuhan mo? Isa,
Mm.
dalawa, o lahat?
Mm.
You have to treat everyone fairly because if isa lang tinerminate mo pero kasama yung iba, dun makikita talaga sa position paper that you favored one person after another, and that will make your labor case weaker on the side of the
Mm.
company. Kasi hindi ka pantay-pantay sa
Yes.
pagtitrato mo sa tao. May inapi
Mm.
ka.
Mm.
Pangalawa, you also have to make sure that you read all the NTEs. Lalong-lalo na
Mm.
pag owner ka or manager ka. Kasi minsan talaga pag binasa mo yung mga NTEs, yun yung rason bakit natatalo kayo. 'Di ba kasi napaka-generic, nakasulat lang date of kailan nabigay, pangalan ng tao, tapos kung ano yung offense, pero walang
Mm.
detalye.
Mm.
Hindi mo man lang tinanong dun sa line manager kung anong nangyari. Tapos
Mm.
later on 'pag nakasulat na binigay mo tapos nakita niyo mali pala yung nasulat, hindi niyo aaminin.
Mm.
Paninindigan pa ninyo na tama yung ginawa ninyo. Case in point, yung preventive suspension na hindi naman totoo. Sabi nga,
Oo.
hindi naman siya kasabwat pero isinuspend mo pa rin. Magiging
Yes.
constructive dismissal yan.
Yes.
You know, if you think about it that way, parang I think that companies, when they terminate, alam mo naman na potential dole case yan. They have to be
Mm.
extra careful
Mm.
on issuing these disciplinary procedures, lalong-lalo na if termination yung huling letter mo. Kasi for every letter that you give, potentially labor case yan. And you need to
Yes.
be able to justify all your terminations. That they
Mm.
are really kailangan, may
Yes.
kaso,
Mm.
meron talagang kaso na nangyari. Tama talaga yung procedure mo. Binigyan
Mm.
mo talaga ng chance si employee na magbago. Pero
Mm.
hindi pa rin kasi matigas ang ulo. Kaya wala ka ng choice para
Yes.
i-terminate yung tao na yon for the goodness of every other employee that's staying inside the company.
Yes.
Pag ganun yung kaso mo, tapos makulit talaga yung employee mo, pag tinerminate mo yan, kahit magdole yan, go. Right?
Yes.
Go, go. Pero I
Mm.
think most of the cases ni attorney, pagbukas niya ng kaso, pagtingin niya ng NTE, tatanungin ni attorney, naku naman to, anong gagawin ko? Which is
Alam niyo,
why,
maganda, Tina, napakaganda na binanggit mo yan. Ha? Yung mga nanonood ngayon, tandaan ninyo, gaano man kagaling ng abogado, yung abogado
mm,
hindi magician. Okay?
mm,
So, maraming mga kaso na natatalo, no?
mm,
Hindi dahil sa walang kasalanan yung empleyado,
mm,
kundi talagang sabog-sabog yung mga ginawa na efforts ng HR. Pasensya na ha, pero
mm,
yan talaga ang katotohanan, no?
mm,
Kasi tingnan na lang ninyo, kanina nga nabanggit nga na notice nga ni Tina sabi niya, paanong nangyari? Something to the effect na paanong nangyari na tinalo ang HSBC. O yan ay napakaganda yan na wake up call sa lahat. Napaka-powerful niyan. Dami-daming pera niyan na pambayad ng abogado.
mm,
Pero 'di ba? Natalo pa rin. So ibig sabihin may problema doon sa part no nung kumpanya. At maging careful kayo sa inyong code of conduct. Pansin niyo yung ginawa ng HSBC doon sa kaso, sinunod nila yung code of conduct nila eh. Kaya sisiguraduhin din ninyo na in the first place, yung code of conduct ninyo ay consistent sa law, consistent sa jurisprudence. Yan ang pinakamahirap na mangyari at in fact, hindi na masisisi yung HR eh. Kung sinunod lang niya yung code of conduct, pero yung code of conduct pala nangyari, hindi pala napag-aralan na hindi nagawang consistent sa batas, sa jurisprudence, sa rules and regulations, sinunod ng HR because sa pagsunod na terminate ang isang empleyado na hindi pa dapat ma-terminate, illegal dismissal. Kaya tingnan ninyo yung code of conduct ninyo. Kung may isa pang benepisyo itong inorganisa dito sa PHRG na talk na to ngayong araw, revisit ng inyong code of conduct. Make sure na yung code of conduct ninyo legally sound. Kasi kung yan ay hindi legally sound, kahit yan ay sundin, mali pa rin ang magiging resulta.
Kasi hindi lahat na nakasulat sa Code of Conduct, 'pag hindi po siya tama sa batas, valid. It
Yes.
at the end of the day, it is the labor code of the Philippines that will still be followed. And I think, Attorney Alvin, your firm accepts reviewal of Code of Conduct, correct po dyan? And
Yes.
contracts. And
Yes.
contracts. Kasi minsan, maganda yung kontrata po ng napasign mo nga. Pero meron kang nakasulat dyan na hindi ayon sa batas.
Mm.
Lalong humina
At
tuloy yung contract mo
at
kasi
kahit sa
dahil sa
batas,
nakasulat dun.
na-mention ni Tina, batas. Kahit sa batas, huwag kayong magre-rely, HR, sa yung reading ninyo ng batas, na pag tiningnan mo, klaro naman yung batas. Bigyan ko kayong example, ha.
Okay.
Klarong-klaro ang sabi ng labor code, sa pagdating sa probationary employment. Probationary
Mm.
employment shall be 6 months. Ang word na ginamit, shall. Di ba ang turo ng
Hala,
high school English teacher natin, pag shall ang ginamit, mandatory yan?
correct.
Pero alam nyo, directory lang. Kasi ang Supreme Court, may mga kaso talaga na dinesisyonan na pinapayagan ng Supreme Court na yung probe period pwedeng ma-extend. Basta lamang sabi ng korte, may pagpayag ang employer at yung employee. Pumayag sila sa extension. Bakit? Bakit? Kasi sabi ng Supreme Court, mas beneficial yun sa employee. Na mas
Tama.
bigyan pa siya ng mas mahabang pagkakataon para patunayan yung sarili niya kaysa sa i-terminate na lang siya kaagad. O pero kung babasahin mo yung batas, mamimislead ka. Kikita mo,
Shell.
shall. Ano ang practical application nito sa
Must.
workplace? Alam
Mm.
ninyo, may mga empleyado, ako nakakita na ng mga ganito. Yung 6 months, hindi sapat sa kanila para matuto. Pero kapag ka nabigyan mo lang ng mas mahabang panahon at talagang natuto, ay very hardworking, magaling, very loyal. May mga nakita na akong ganyan. Kaya huwag kayong maglimita. Ay, sabi ng batas, shall. Oh, sabi ng Supreme Court, pwede. Basta pumayag ang employer at employee. Ang point dito, main takeaway, huwag kayong magdepende lang sa kung ano yung nakikita ninyo sa batas. Mas
So
makakatulong
in
sa
short,
inyo. Magtanong kayo sa abogado kahit hindi ako ang tanongin ninyo. Basta make sure lang yung abogado na yun ay nakakaalam dun sa tinatanong ninyo.
terminate properly, terminate with cause, and make sure that you are well protected in the law, and always confer with your attorney before issuing that notice of decision. I'm very, very important. Lalong-lalo pag magto-terminate kayo, make sure you have your attorney review
Tsaka
the
ito
notice of
ma-inject, no,
decision and
ma-inject
the
ko lang, very
evidence.
important ito, ha. Lalong-lalo na, no, with all due respect to our
Mm.
Chinese brothers and sisters, ha. Ako, I have Chinese blood, kaya that's why my middle name is
Liao,
Liao,
Liao.
eh.
Mm.
Please take note, ha. Iwasan ninyo yung empleyado nagawa ng lahat ng HR, maayos yung pagkakagawa. Sinabihan na nung abogado yung management, okay, tama yung mga nagawa ng HR. Pero yung owner, gusto pa rin magbigay ng bayad ng pera, pera, doon sa empleyado na terminate para lang wag magdole. Iwasan ho ninyo yan. Alam niyo kung bakit? Ito ho
Mm.
yung mensahe na pinaparating ninyo sa tao ninyo. Anong mensahe? Pag ikaw, sorry for my term,
Tama.
gago, lalaan mo pa yung kagaguhan mo. Para pag tinanggal ka, babayaran ka pa. Huwag kang magtitino-tino. Kasi pag magtitino-tino ka at well, gusto mo nang umalis sa kumpanya for any reason like greener pasture or what, wala kang makukuha other than yung final pay mo. Samantalang kung gago ka, dahil sa kagaguhan mo, tinanggal ka, babayaran ka ni boss para lang huwag ka magdole. Nakita ninyo? So nag-i-encourage kayo ngayon sa mga tauhan ninyo na manggago, nagaguhin yung kumpanya. So ingat kayo dyan. Lagi kong dinidiscourage yung kayong pagtama naman ng pagkakadismiss sa kanya, dahil lang sa natatakot kayo na baka kayo idoli, bibigyan nyo ng pera, wag. Kasi malalaman, kahit sekreto yan, malalaman at malalaman yan ng mga kapwa niya empleyado. At napakamali na president ang inyong ginagawa kapag kaganyan. Delikado yun para sa kumpanya.
Hindi ibig sabihin 'pag ang tao nagreklamo sa DOLE, sigurado matatalo ang company. Hindi
Yes.
ibig sabihin na 'pag nagreklamo, kailangang bayaran, kasi dun din mapupunta na babayaran mo. There's so
Yes.
many labor cases that are
Oo.
being dismissed for lack of
Oo.
evidence. And example for us, parang merong taong nag-absence without leave, ayaw magpumalik, tapos ang sinabi na-dismiss. Eh, ang
Oo.
totoo, employee pa siya eh, hindi pa siya nadi-dismiss. Inunahan na niya yung company na illegal termination daw. Wala naman talagang kaso. It
Yes.
is highly possible NLRC will dismiss the case
Yes.
kasi sanay ng NLRC sa mga junk cases na
Oo.
ganyan.
Oo.
Huwag tayong masyadong matakot. Just make
Oo.
sure, number one, you hire a very good law firm like Attorney Alvin Liao
Ah,
Alburo's law firm to double check your documentation. Number two, make sure yung HR ninyo hindi tamad magsulat. And number three, listen once again to Attorney Alvin. Attorney Alvin, may part 2 daw. Ang daming humihingi. Ang daming humihingi. Part 2,
Ay,
please.
malakas sa akin si Tina, kaya walang problema.
'Di ba? And with that, thank you so much everyone for spending your weekend habit with us. And thank you, Attorney Alvin, for your time. I know you're very busy, but we
At
really
muli,
appreciate
maraming salamat din,
you
Tina, sa
here.
pagpapaunlak sa imbitasyon ng Soler sa iyo. Maraming salamat.
Maraming salamat po. Thank you so much.
Bye-bye.